Okay, so just have to let him in until I get in place. Good morning, everyone. Can anybody hear me?
I can.
Good. We got one, then we probably have others. We're, just about 9 o'clock. And we're just warming up my vocal cords right now and letting people in.
Ask them to mute unless we're talking.
Yeah, if you could please mute your computer unless you're talking, that would be appreciated. So let's get started. Welcome to the court accounting class. Exciting stuff. It's a necessary aspect. I'm Rex Crandall. I'll be one of your instructors today. This is Tamara Brown, who's an LDA, a tax preparer, and I'm a CPA and attorney. We've given this class now for probably over 4 or 5 years, and we enjoy doing it. It's a volunteer activity with the Contra Costa County Law Library, and we're trying to help self-represented people and also others who have a necessity or desire to learn court accounting, and usually people with conservatorships, guardianships, probate cases, sometimes trusts have to do the court accounting. Our objectives
Oh,
today,
it's okay. I got it.
we got one person with a mic
I
on.
don't have a big hard drive recording video.
Okay, so what the objectives of the class today is to give you an orientation, to give you an overview of what's required and how to do it. It's different than other types of accounting, and it's just unique to California. It's all generated by statute. And we've included government forms for your use.
He's admitting. Okay.
So the overview is that, and objectives, by the end of today, you may not have learned everything you need to know about court accounting, but you have materials and you have instruction. We also make this video available on YouTube, so you can go back and review. And as you're working through the court accounting, you can learn the pieces that you need. And we're going to be showing you 2 different methods of doing the court accounting. One is on the judicial council forms, and the other is the method of using kind of like a spreadsheet. And so it's 2 different methods. And we have materials that you may or may not have downloaded yet. I'll just tell you what the materials are that you might want to have open at some point. The call it number 2 handout is court accounting. There's another handout that we have here is called the non-follow along handout, and this is reference material, helpful explanations, errors, things to avoid. And then the last item that we have in the LinkedIn material is the evaluation, the course evaluation. And we would appreciate it if you fill that out at the end of the class. So those are the materials. One of the things, if you're doing court accounting for yourself, this is the right course. The other thing, if you're a service provider, do legal documents for people or for family or for friends, you're a bookkeeper, there's no required license to do bookkeeping in the state of California. You do tax returns, yes, you have to have a license, at least a CTEC or an IRS enrolled agent or a CPA or an attorney to do tax returns, but no license required to do any type of bookkeeping for businesses, and including court accounting. There's a couple parts, which we will cover, one of which is the accounting itself. The other part, when you're dealing with the courts, you have to have a petition that goes with your accounting. And if you're a pro per handling litigation yourself, or you're a legal document assistant or law firm, we are going to cover the basic components of what's needed in the court petition. I have, there's required court accounting for guardianships, conservatorships, and probate. For trusts, it's optional. And for trust, there's some good reasons to get your court accounting approved as a trustee. And one of those is that you cut off liability for the trustee. You give notice to all of the beneficiaries, and they have an opportunity to comment or object on the accounting. And once the accounting is approved, then the trustee is no longer liable for litigation claims against the trustee personally for things that have been approved by the court. We're going to be covering a lot of detail, and so you kind of have to follow along and try to build some perspective on the detail. And right now, I'm going to start on page 23. I'll try to, it's actually your material, it says 21. I'm going to let you find that first.
You're gonna start with the inventory and appraisal with me, not that.
Okay,
page.
I take that back. I've been corrected. Let me get the starting place. Inventory and appraisal. Okay, so on my PDF, it says page 6, but let me get the page number from the book. It's and the big numbers on the lower left are the page numbers in our materials. This one has about 6 zeros and a 5. Hopefully everybody's onto that page now. And what we're going to do is cover the inventory and appraisal, which is the beginning numbers. Then Tamara's going to teach that part. And then I'm going to come back and talk about all the detail during the year and the transactions. And then after that, Tamara's going to come back and teach you how to, what's included in the court petition. So let's get started.
Hi, y'all. I'm gonna somewhat kind of go a little bit fast because there's a lot of information. The court accounting part's really, really important. And I'm going to show a few examples. I will tell you again, as Rex said, I am an LDA. I've done this class teaching for quite some time. And some of my examples, I'm gonna change this up for those who have taken this class quite a few times or more than once. I'm gonna change or add a little bit to what I explain, only because of the fact that recently, I'd say within this year, let's say, I have had the pleasure of correcting some court accountings that have been turned in and rejected by the courts. And I realized that the court accountings that were turned in and rejected were from people who took the class. So that tells me that, not that I failed in teaching, but it tells me I need to provide a little bit more details in how to do things. And so I'm going to try and cover those things and what I learned just from doing the correcting of some accounting. And so I will incorporate that information in here. I know that there's a few of you who are, so let me explain to those who are in here. Some of you that are in here are doing your own accounting for conservatorship because you don't have legal counsel, or you've decided you want to tackle this on your own and see how it's done. And then we have other people who are here that might be LDAs that are looking to do this for clients who contact them. So there's a few differences between the two people, although you're coming together to do or accomplish the same thing. For LDAs, we have to be very careful about giving legal advice. So I'm not doing this in any way to give you legal advice. I'm just showing you exactly. This course has been approved by Judge Sugiyama, who is now retired from Contra Costa County. It's been viewed, and of course Rex, who is an attorney, has reviewed it a lot. So there'll be a few things that I say that some LDAs will go, oh geez, I can't say that to a client. But so I'm really going to direct this class for those who are trying to do this on their own, and how you put this all together. So the first form, or how, when a court tells you, especially for a conservatorship, so on a conservatorship, typically the accountings due the first year after you receive letters. And then after that first accounting is done, it's done every 2 years after the fact. So I have much experience in the first accounting and then the second accountings. This class is basically going to be taught as if you're doing your first accounting. If this is a second accounting, so you've already done your first accounting, the steps that I'm showing you right now at the very beginning will not be done by you because it's already been done. You will just take off and do the second portion, which is what Rex is going to teach. You'll do a second accounting. So it'll be a little bit different if this is your second accounting and you're still trying to learn. Okay, so I'm going to quickly go through the forms. The first part, when they state an accounting is due, or they want an accounting, or you need approval, or the courts will say we want a status review, or if there's anything like that, this is what they're asking for, or what they're needing, what they're doing. And so this form will be completely blank. So let me tell you that this is just a sample for you. So you write all over it, put your own notes. You may want to write in things I say so it'll jog your memory when you do your own. But again, you're gonna, if you needed to, you could search the web for this exact form that's up here. Most of the time so what does it stand for? So DE is decedent's estate, and then GC is guardianship conservatorship. So the form is used by both. So it is the form that you would use. Okay, so again, this is going to be blank, and how you would start it off if you were a pro per, or if you're an LDA preparing this for a client who is pro per. This name up here, which shows an attorney, it would not show that. It would show your name, and it would show your address. So again, this first caption right here is going to be your name and your address. If you're preparing this, it'll be your phone number. Fax is optional. Email address is optional. But I will state, I used to have attorneys when I was preparing these for them, they'd go, I don't want my email address there. I don't want my email address there. But I was telling them that if the court examiners who will review this first before a judge, or the court in any way wants to contact you about this, they're not picking up a telephone rarely. They will look for an email address or a fax number so they can fax notes to you, or fax what they want you to correct, or fax what else they want added to this. So providing this email address is really helpful. Okay, going down to attorney for, in this case, this is kind of a form as if there's an attorney, but you are filling it out yourself. You would put your name. And in this case, it would be pro per, it wouldn't be conservator. So again, it would be, I'll give you my name, Tamara Brown, comma, pro per, P-R-O, and then space P-E-R. And that just tells the court you're representing or you're coming in yourself. The this is filled out, this is for whatever court you're in. In most of my cases, I'm in Contra Costa, I'm in Solano, I do LA, I have a lot of Marin. So it's dependent upon what court you will put that information in here. So you will find out the address of the court, the branch, and all of that. So now we move on to, it says estate of. What does that mean? In a lot of cases, it could mean something different. One, this person, that the name right here, could be a decedent, which means passed away, and so you're doing a probate. Or it could be a conservatee, which means typically that's an older person or someone with disabilities who is an adult over the age of 18 and needs to be conserved. Or it's a minor, which means you're doing a guardianship. So you would put the person's name that is receiving the care or who is the decedent. It's the person that you're going to court for. And then you would mark which box it is. Now we get down to inventory and appraisal. Okay, there's several boxes and it can somewhat be confusing, like which box do I use, why? The first one is a partial. A partial would be, say for instance, I'm going to use the example, we have a conservatorship here. So the conservatee comes in, you get your letters, and you want to do an inventory and appraisal, or you need to do an inventory and appraisal. But say you are not sure if you have all of the assets of this conservatorship. So you may have, let's say you have property in another state, or there might be stocks that you think you know that you have, but you haven't been able to actually zero in and figure out if that's all you have. Then you would do a partial, because you're telling the court, this isn't all the assets, but I'm going to turn in a partial anyway. Most of the time, I don't like doing a partial. I usually wait, and there's no specific reason that the inventory and appraisal needs to be rushed, except for, let's say, if you've put it off and you have a court case coming, your hearing coming up soon, that's a different story. In that case, I would still mark it as a partial and say, I'm doing the best I can. I just don't know everything yet. The other one is corrected. So say you turn one in and you found out, oops, this is wrong. I will give you some examples in just a few minutes when I move on when we would use a corrected. Most of the time you will mark it a final, which means I've marshaled all the assets. I know everything I have. This is it. There won't be anything more. Then you would mark this a final. Now in a probate case, okay, so you have a probate case and let's say we have real property. So you were given, in a probate case, you can be given full authority or limited authority. Full authority means you as the administrator have full rights to sell property, to liquidate property, to do whatever you wish with the property without court approval. Limited means that if you have a house sale or you're going to do anything, it needs to be conducted with the judge. So let's say you want to sell the property and you have to submit the sale in front of a judge. Judge has to have a hearing where the buyers come in, you conduct a sale in front of the judge orders it and stuff like that. In that case, you have to do what's called a reappraisal. And that is because this inventory and appraisal, when it goes off, and I'll explain more about that later, is as of the date of death. So let's use this example. We have the date of death here of March 8th, 2012. Well, we're in 2022. So the appraiser, probate referee, who is appraised and given values, has given that value as of the date of death. So now we're in 2022, and the judge wants to know what's the value today. Like, he's not a real estate guy or gal. And so they do what's called a reappraisal for sale, which means this is sent back to the probate referee to say, as of today, 2022, what's the value of this property? So say it's, I don't know, a condo, a house, it doesn't matter. The probate referee comes in and says it's worth $1 million, or today's value is $1 million. But the sale that came in, or the buyer that came in, offered only 700,000. I can tell you it's likely the judge will not allow that sale because the value is not there, or the sale price is not where the value is. So that's the reason why you would mark it a reappraisal for sale. Then you have the supplemental and then the property tax certificate. Those are rarely used. Okay, so I will tell you, this inventory and appraisal is very important. Sometimes it's not done at the beginning, and sometimes it's forgotten about from ProPERS. And I will tell you a little bit more. Let me get over to this other side, and then I'll go into more details. So in this side, you'll have your case number. This case number was given to you at the very beginning when you opened up the case, whether it was a probate, a conservatorship, or a guardianship. And then you have the date of death or the appointment. So date of death, of course, would only apply to a probate. Conservatorship would be when you got your conservatorship, or for a minor, it would be when you received letters for your guardianship. Okay, this would not be done. So I know one of you that's on here that's going to be doing the accounting portion for a trust administration. So for a trust administration, you do not need the inventory and appraisal. You would just jump right into the accounting. Okay, so it's a little bit different for some of you that might be on here. So anyway, that's what you have here. And then you go down and you get started on, okay, what else do I need to include? It talks about appraisals, and this is what you're doing, inventory and appraisal. So down here, it says total appraisal by you. So you're either a representative, you're either a guardian, or you're either a conservator. And it says you will record all of this on attachment 1. So attachment 1 is very specific. It is only cash and anything that can be turned into cash. So cash is a coin, cash is a check, cash is obviously money, cash is not stocks, cash is not a house, cash is not jewelry, cash is coins. So you really have 2 buckets that you have to take your assets or whatever it is of the decedent, of the conservator, of the conservatee, sorry, you are the conservator, or of the minor. So what does that mean? That means I receive my letters. I'm told by the judge that now I'm in charge of somebody, or somebody's estate, because they're no longer a somebody. So I have to go in and I say, okay, what do I have? And so basically you're walking, you could be walking into somebody's house and you're going, okay, now I've got to do an inventory. what do I have? That doesn't mean sit and write down, they have 10 pairs of shoes and stuff like that. Doesn't mean it at all. It's kind of what is the important items that we have here. Now, the other thing I say, which makes this extremely important for if you're pro per and filling this out, and or you are the other side, which is an LDA. If this inventory and appraisal is wrong, I'm saying if it's wrong and you don't know it's wrong yet, but if it is done wrong, your accounting can never be done. It won't balance and you can never do it. So this actually is a very good point, and why the 3 accountings that I have redone and resubmitted and the court rejected was because the inventory and appraisal was wrong. So what happened was when a court accounting is done and I reviewed it, the first thing I asked for is the inventory and appraisal. I received an inventory and appraisal and it said cash, let's use this example, was 57,844.59. I went and grabbed the bank statements, looked, and I said, okay, we got major issues here. That's not what the cash totals. So say for instance, my cash totaled 75,000 when I put it together. You absolutely have to stop your accounting because now this inventory and appraisal has to be corrected. You can never do the accounting if this inventory and appraisal is wrong. So that's the first thing that you're going to look at if I was to take on an accounting project, or you are a pro per and you're going to do the accounting. The first thing you need to do is verify that your inventory and appraisal you turned in is accurate, or you can never start your accounting. It would be, you're going to spend hours and hours and hours and you're never going to get it balanced. So it's going to be really important that you pay attention and this is correct. You can make a mistake. Hey, I thought when I first started, I had all my assets. I found another bank account. Then of course you will do a corrected one. Or say for instance, I had the other thing I had, as we'll go through, and when you figure out your cash numbers, is I had a client get a bank statement and he got his letters, let's say on March 15th. And when he looked at the bank statement for March, it said March 1st through March 31st. He put the balance that started on March 1st. Well, that's not going to help you. You're not going to be able to balance. So you really want to pay attention and make sure your inventory and appraisal is correct, because you can't move forward. Okay, so we're going to go ahead and start on attachment 1. I'm going to slide the page down, so I don't want to make it blurry, but let's go down to attachment 1. So again, this is going to be a blank page. It is a different form. It is the DE 161 and the GC 041. And up top here, it says, what is the estate name? So again, this is the person that's either the deceased, the conservatee, or the minor. And I'm going to slide up, so don't watch it is going to be the exact same name that you put here. And right along the right side will be the case number you put here. That is what's going to go right there. Okay, and you as the person preparing will put this attachment number will be blank. So you will put number 1, and that indicates it's your cash assets. Okay, typically the page 1 of 1 will appear down here at the bottom on most forms that you get off the internet. So it could be here or it could be down at the bottom. But how you're going to start this is you're going to number it just like they do along the side. So in our case here, we have 7 items of cash. You're going to try and do a description that's as descriptive as possible. I myself don't go into all these details, but, and most other people don't, but it is good that if you wish to. But so we have the first line item that says cash. A lot of times you'll walk, especially into older people's homes. I can tell you my father has cash all over the house. My mother, unfortunately, she passed away, but when she passed away, we found envelopes of cash in the closet, in her, dresser drawers, all. Pay attention to that kind of stuff because older people do their cash. Nowadays, the younger crew, my kids, they barely even know what cash is, right? It's a ATM card. That's all they care about. So you have cash found, and in this case, they were very descriptive and said the cash was found at the residence. And what was the amount of cash found? So in this case, $250. We have balance in a checking account. Again, this is public information. Anybody can obtain a copy of this document. I do not like to put the entire account number, and or if I'm preparing this for clients, I also tell them, do not provide me the entire account number. I always ask for the last 4 digits. We will get into, or in Rex's part, you must provide original bank statements. I also tell everybody, or like to tell everybody, to do what they call redacting, which means you'll white out the entire, all but the last 4 digits. The courts are really just trying to verify the account number is what you have here. So they don't want the entire account number either, but you put the conservatee or the minor at risk by putting the entire account number. And I have also seen probate examiner notes that come back that state that you are violating your duty because you're putting, you're not preserving the confidentiality of the client's, information. So never put the entire account number. It's not necessary. It's not needed. And you're really risking somebody else getting a hold of this document and knowing an account number that belongs to a specific name. Because as you will see here, if I know your entire account number, I know what bank you go to, I know your name, I know that you passed away, let's say, I'll show you, I know you passed away on this certain date. I've got a lot of information that could jeopardize, or somebody who is not a lawful person could possibly get information that's just not necessary. So keep as much information confidential. Last 4 digits. I myself don't go as far as putting a name and an address of a bank, especially if it's somebody like Wells Fargo. I don't even need to know what branch because Wells Fargo is everywhere. So I will typically put balance in the checking account, last 4 digits, Wells Fargo Bank. And then you want your balance. Again, this is the balance on the day you receive your letters. So let's just say most bank statements will run for an entire month. So you have, I'll just use March. March 1st, you have a bank statement that you received, and it goes from March 1st to March 31st. You received your letters on March 20th. So you have to be very careful that this balance that you put on here is not the beginning balance you saw in the bank statement. No, a lot of times now banks will have a running daily balance along the side of the bank statement, and you will, and or you can go to the bank and ask them, okay, I need to do an inventory and appraisal on March 20th. What was the balance? That might be an easy way, but you want to make sure that you put the balance on the day you received your letters. The important part of that is you are not responsible for any transactions that happened anytime before. So on, let's say March 15th, there was a check to your best friend for $50,000. I'm just saying. And one of the heirs, one of the beneficiaries says, wait, hold on. There was nowhere, nobody said she could give $50,000 to, you know, her best friend or whatever. And they want to go to court and hold you responsible for that $50,000 that went to a best friend. That would not happen because you were not in charge at that day. So whatever took place has to do with, it wouldn't be a minor who would write something like that, but say the conservatee, it's on her or him, sorry. So it's really important you write the balance on the day you were issued letters. Okay, so same thing with the savings account, last 4 digits, what was the balance? In this case, we have a certificate of deposit. You put all the information that you know about it. A lot of this description's a bit much. You might not know the information, but again, I typically would only put certificate of deposit, part of the account number and details of it, and then we put the amount over here. In this example, which this example might have been done quite a few years ago, there is uncashed checks. You have to list them individually if there's more than one. So nowadays, pensions, Social Security, stuff like that is direct deposited. So you won't have this much, but there may be a case where a neighbor bought something from you or something and sent the conservatee check and it hasn't been cashed yet. You would indicate that here. So you'll see the example. This was a check that came in from the pension fund. When was it dated? Who was it paid to? And what was the amount? Another example would be an uncashed check from Social Security. And here's the amount. Then we also have what used to be dividend checks that were issued. So somebody who has a dividend account, there's 2 ways. Dividends are either reinvested or they're issued or paid to the person on a, I don't know how often basis, maybe quarterly basis or maybe yearly basis, or could be monthly basis. I don't even know that real question, but in this case, you would indicate that here. Okay, and then you would take all of this and you're going to come up with a total. You will put this total at the bottom. And then you would take this total, again, I'm going to slide the screen. And you're going to put that exact total right here. Everybody following? Anybody have any questions before I continue on with the next one?
Sure. For the trust, what's entailed in the accounting? I know you said they could skip the inventory and appraisal, right?
I'm sorry, hun. I need to turn up the volume. I didn't hear the beginning of your question. What was that?
Oh, sorry. In terms of a trust accounting, what's entailed or required for the accounting for a trust?
Okay, that we will go into a little bit later, hun. This is the inventory and appraisal, which you will not need.
Okay.
So when Rex comes back in and starts the trust accounting or the accounting portion, that's where you would that's where you would really want to pay attention there.
Okay, got it. Thank
Okay.
you.
Camera,
Yes, hun.
I have a question about the date that you would start the accounting if you have temporary letters. I don't have final letters, but temporary letters of conservatorship. So would I start the accounting as of that date or wait until the court says something else?
Okay, you're fading a little bit, but I think I got it. With temporary, you are also responsible. So you would start it the day you got your temporary.
Okay, got it. Thanks.
And was that Maria?
Yes.
Hi, hon.
I have a quick question.
Yes, son.
So if the conservatee has a retirement account
Uh-huh.
and there is cash in that retirement account, do I list that under attachment 1?
The retirement account, I believe, is kind of a non-cash. I think that's valued by a probate referee.
Wait, can you say that again? You were cutting out.
I'm sorry. I said, I believe it's a non-cash item that's handled by the probate referee, huh?
Okay, I don't know what a probate referee is.
We'll get into that second
Okay.
part. I will get there.
Okay, thank you.
Uh-huh. Anybody else? Okay, great.
I have a quick question.
Yes.
Just want to confirm that the balance of the account is based on the date letters are issued, not date of death. Is that correct?
That's correct.
Okay, thank you.
Because, and here's the purpose for that, hun, or here is the purpose on what is the difference between kind of the date of death and when you get your letters. So the date of death happens, and say, for instance, the person wrote, they didn't even know they were passing and they were in good health, and there was, I don't know, a car accident or something, and they wrote a bunch of checks. Now, those checks are going to start cashing. Let's say I'm looking at the speaker to talk. I'm so sorry. So the let's go. So the person writes a bunch of checks, right? And God, something happens catastrophic and they pass away. Those checks will start cashing. You're not responsible until the judge tells you you're responsible. And then that's when you're able to go to the bank. You get control of the bank accounts. That's when really you have authority to do anything. And that's when you're held responsible. So the between time between the decedent's death and when you become appointed, you're not responsible for any transactions that happen during that time.
Okay, thank you.
You're welcome. Okay, ready? I'm going to move on. So we're going to go on to number 2, which is the appraisal by a probate referee. So in different cases, some, again, if it's a probate and a decedent estate, when you apply to be the administrator on a probate, you indicate on the first petition form if there's any cash assets or non-cash assets. Typically, your non-cash assets could be, and we'll go through them, but let's say there's a house, that's real property, that's a non-cash asset, or a retirement account, that's a non-cash asset. So if you have those type of things, you will indicate it on your petition that you have cash and then you have non-cash assets. At that very time, the judge, when they issue an order, which is, I believe, the DE 140, when they issued the order, at the very bottom of the order, there is a spot right up above their signature that says assigned probate referee or probate referee assigned. And sometimes the courts will just stamp on the right side of the order somewhere, sometimes in the middle, not in the middle of the page over like writing, but they'll put it in this like white blank space. They'll just stamp the probate referee's information. It will have his name, his or her name, and then a contact phone number. And Usually it says they're a probate referee. A probate referee is only, they're approved by the court. The judges circulate them, so they have a pool of, I don't know how many, but it appears I get quite a few of the same probate referees, so it's not a huge pool. So they'll assign what they call a probate referee who must give value. Now, if you tell the court when you complete your petition that you only have cash, and really the court will go, okay, you only have cash, you will not be given a probate referee because it's not necessary. You value the cash. So there's been times where a petition is filed, they don't know there's non-cash, and so they will only say there's cash and then all of a sudden determine that there's non-cash assets. In that case, you have to get a revised order because you don't have a probate referee, or you would have to complete a declaration or a petition and ask for a probate referee. You cannot just pick it yourself, and you cannot do the value. I mean, you cannot indicate a value for that. So again, your letter, your order, sorry, not your letters, your order will state your probate referee. It will be at the very bottom, or you'll see that they'll check the box that says probate referee, and there will be a stamp somewhere indicating who that probate referee is. If you completed a petition, I'll say this now, if you completed a petition and you said there's non-cash assets and you get your order back and there is not a probate referee, you would have to go to like the probate examiners, or you would have to somehow go back to the judge and ask for a probate referee, and they will give it to you. So what is a probate referee's job and what do they do? Well, we're going to get to that. That's going to be attachment number 2. Okay, same form as attachment number 1, except for you're going to indicate it's attachment number 2. So here's our attachment number 1. We completed that. And now we're going to move on to attachment number 2. Wow, it looks exactly the same. So you will put the estate name up top here and the case number. And where it says attachment, you will actually put number 2 in here. Typically, you'll only have page 1 of 1 unless you have tons of non-cash assets. In that case, you may have more than 1 page. But what are you going to indicate on attachment number 2? So we're going to indicate all of our non-cash assets, which we cannot value. So the first one will be, I'm going to indicate real property. Okay, that's a house. So my house is in the city of Newport Beach, the county. You're going to try and give as much description as you possibly can to the probate referee. Although they have lots of knowledge, they have a lot of stuff they can look up and they will know. I like to do the best I can and give them as much information as I can. In this case, this example shows almost the, not the entire legal description, but a lot of the legal description. And most, let's just say the average person will not know that or not know how to obtain it. So say for instance, I took it on, I really don't know a whole bunch about real estate. I don't know how to pull deeds. I don't see a deed here. I would just list real property in the city and provide the address. Okay, as you will notice in the appraised value area, blank. There is a purpose for that. You are going to send this entire package to the probate referee. It is not your job to value. And in fact, if you put a value in here, they're going to laugh at you and then white it out. They probably won't, you won't even know they're laughing at you, but they will laugh at you and then white it out because that's their job. And so their job as the probate referee is to give the value to the court. And to you, of course. Okay, so let's go on to number 2. In this case, I believe we have a conservatee, yep, has a vacation home. Where is that vacation home? I will indicate, commonly known as 2446 in Palm Springs. Again, 0 value. Now we have other cases like household furnishings at 121 View Place. I will tell you that in my experience, many years of experience at looking at these household furnishings, you will likely get a $500 value, maybe $1,000 value, depending on if they look as how big kind of the house is. It's not going to be much. And a lot of times I will just lump in the furniture and fixtures and furnishings, unless there's something in there that I determine might have value. And if that's the case, I would list it separately, like an antique dresser, very good shape, it's wood, or marble, or maybe if you walked in and saw vintage furniture that looks like it's very good shape. Not a whole lot of times you'll see this, so that's will be quite the different scenario. Most of the time it'll be just your average furniture and fixture, and there's not much value to that. If you can imagine, the probate referee gives a value of, say for instance, what would it be worth at a Goodwill or a garage sale or something like that. That's the value you will see in here. So again, if you believe the furniture is worth something, let's say we get down to a, let's say you find a Corvette in the garage. Do you think, well, one, they're going to ask you what year it is, but if you could only imagine the difference in value, believe it or not, from a 2020 Corvette and a 1927 Corvette, it's going to be huge. One's a collectible, and the other's just made of plastic. Well, probably really nice plastic, but the difference between them, you will want to indicate and tell the probate referee. A probate referee is not driving to this house to look at any of this. They're just sitting at a desk giving a value. So if you think there's value on something, indicate it, separate it out, put a little note down here that says, I think this has value, or maybe it's been appraised before and you've seen, or it's a friend of yours that says, I had this appraised and it's $100,000 or something. Maybe you want to attach that appraisal. Do whatever you can to help the probate referee give the value that you think it's worth. Okay, so now we're going to move on. In this case, there's shares in a mutual fund. Again, the hardest part, I think, of that one is, how do I determine how many shares this person has? I may see a statement come in, or I may not. They may have told me that they have shares. You're going to have to do a little bit of homework. Try and find a statement that's come last. Try and do what you can to find out how many shares are there. But again, you do not provide a value. Only the probate referee values. Okay, we have another case where they have 100 US savings bonds. Again, you don't give value. Now, I use the example of a diamond ring and 2 carat, and most people say, okay, what is the importance and what is the difference? Okay, so say you have a conservatee and they have children that lived in another state and possibly haven't seen their mom in quite some years or father in quite some years. I'll use mom because it's a diamond ring. One of the hardest parts for me is, I know, but I'm really not into diamonds. I couldn't tell you the difference between a 2 carat, a 1 carat, or maybe a 4. Maybe I'd look at it and go, it's big, so I don't know if it's 2, but I really wouldn't know the difference between them. So this would be a really hard one for me to go in. Do your best guess, but I'll tell you right now, what's going to happen is, say you're a conservator for a conservatee and her children get a copy of this and they go in and you've listed a 2 carat diamond ring. That's all the jewelry they have. And they go, hold on a minute. I was with dad and he bought her a 5 carat. Now, how did it get down to a 2? You know, this gives them the opportunity also to say they may not believe, or they want something different, or they want you to look for a 5 carat, or something's wrong here. But when you, let's just say, the more information you give and the more you're upfront and the more it doesn't look like you're hiding, or the more you're trying to show you're not trying to do something wrong, or you're just putting your best foot forward, and I'd look at it and go, honest to God, that's all I saw, you know, and I'll testify under oath if I have to. It only looked like a 2 carat to me. If you want to come and I'll go with you, or, you know, whatever, it might be something different, but make sure you indicate that on here, because there is, let's say, a lot of cases that go through the court system for people who think that there has been theft involved, or maybe mom traded it in and you didn't even know about it. Maybe she wanted something smaller. You know, it just gives the opportunity for all the heirs to know what they have. Okay, so again, no value here. And at the bottom, you'll see no value. And again, what is the purpose? I'm going to slide up the form. What's going to happen is you're going to send this entire form with all the attachments to the probate referee. What they are going to do is provide value. I'm going to slide down again. They're going to provide value on this sheet right here. So when you get it back, there will be value. $1 million, you know, 500,000, and then they'll get down to a total and say their total is 2 million. They will put the 2 million here, and then they're going to put the 2 million here, and typically they will total. So there's going to be a total on this line. That doesn't look like there would be a total there, but they will put a total there. The next thing they'll do, I'm going to slide down again, is they will complete this declaration. So they will put what their commission is. They will put if there are any expenses. Let's say, I'll use the example, mileage, postage, say it cost them money to do a search, or say they had to pay, I don't know, fax fees, fax filing, or whatever it is. They'll put their expenses here and they will give a total. And this is what their total is for what they charge you to do what they did. But they must provide that to the court also. So say, for instance, if a court got this and the probate referee charged $100,000 to do a job, that's crazy. But they wouldn't. But say they did, the court would look and go, they would have a conversation with this probate referee. So anyway, this will be the total, and the probate referee will send you an invoice for their fees that's payable by the estate or by the conservatee, etc. but that will be their total. They will date it, they will put their name, and they will sign it, and they will return it to you. The entire form with all of the attachments. Now, this takes, and I forgot to say this at the very beginning, technically your inventory and appraisal is due 90 days after your appointment. That's pretty fast. That would mean you really should be jumping on it and getting this going, because a probate referee takes quite a few weeks. I will tell you ahead of time. So if you have a court hearing coming up and you forgot about this and you want a probate referee to rush anything, good luck. But maybe it could happen, maybe not. If that was the case, I would probably indicate in a letter along with this form, a letter that states, oh my God, I'm so sorry, I forgot, I have a hearing coming up. Is there any way I can get this on a rush basis? Blah, blah, blah. But otherwise, I always include a letter to the probate referee anyway. In my cover letter, I like to say, introduce myself and not introduce myself, introduce the person that's preparing this form, but introduce themselves, state that on this court date, the judge ordered you as the probate referee. Please let me know if you have any questions, if I completed the form wrong, anything like that. I'll give a phone number that they can be contacted, and I put all of that in. That's not necessary. You don't have to. It's my own little touches that I like to be. Hi, here we are. Please do this for us. It hasn't won me any brownie points that I know of, but I still like to do it. So that's an option, whether you want to do it or not. Okay, so you're going to get this form back. And so you will have it totaled down here. And these numbers, three numbers or two numbers, will be carried forward to your accounting. So again, and Rex will go through that portion. If these numbers are wrong, this is where I'm telling you, your accounting will never tie. You'll never get it to work. You'll never get it properly balanced, and you're going to have a whole heck of a lot of trouble when you get to your accounting. Okay, let's complete the rest of the form. So the first box is attachment 1 and 2. They're talking about this right here. Attachment 1 and true, or true and correct, and include all, if you're doing a partial or a corrected, or maybe not in a corrected, it could be, or it's a portion. So again, if you're only doing a partial, you're indicating, this is only a portion. I'm not sure if I have everything yet. And keep in mind, if you mark a partial and a portion and you determine later on that was all that you have, then you still have to go back and mark it final, because if until it's final, the courts have no idea if you're done or not. Okay, so then we get down to question number 4. Was a probate referee required? If you only had cash in this instance, if you look at this example, let's just say you only have cash. So no, a probate referee was not required. The second scenario, because I gave you examples of an attachment to, is you will mark this box. Yes, a probate referee was given. When was it given? It was given on your order. So look at the order and see what date the judge signed it and ordered the probate referee. That's the date you will indicate here. Now, I will tell you that a lot of times I've seen this box marked and no date was put here. Don't freak out if that happens, because I've seen it over and over, and the courts do not seem to reject it if that happens. But I like to indicate the date it was ordered. Okay, now you have property tax certificate. This number 5 is only if you're having a sale of property, or could be other reasons that you would complete this. A property tax would mean you have real property, and are the property taxes paid at the time of death they didn't own real property. So you would indicate, so not necessarily number 5 will have a box marked. Okay, so now we're getting down to this part. You declare under penalty of perjury, all this up above is true. You would date it. And let me tell you, this is so funny because I know this form, so I have client, I get these back so many times, and they'll sign their name over here, and I'll look and I'll go, dang, they didn't date it. So then it'll go back and I'll state there must be a date on the inventory and appraisal where the signatures, and they'll give it back to me. There's no place to write a date, or they'll write a date next to their signature over here. And I always have to tell some people, it's right up above where you type your name. They don't see it for some reason. So a date, you need to date this. And then this name right here, printed name, is you, the pro per. So you are signing this. Here's the other thing, as you'll see on the example, it says, do not sign it before the probate referee has returned the form. Because you're signing this under penalty of perjury, you don't want to sign it before you know what they're going to write, because you're kind of responsible. And so again, you want to see what the probate referee puts in here, and then you want to sign it. Now we'll get down to a bond. When you apply for a probate, you will know if you have to provide a bond. A lot of times there are many cases where the judge will require, typically a judge will require, if you have 57, okay, I'll give the example, I'll ask somebody to answer. So at the beginning of the court hearing, the judge ordered the minimum bond, which is $20,000, okay? So the judge orders a bond, you purchase a bond, you get a bond for $20,000, and then now you complete your inventory and appraisal, and you have $57,000 worth of cash. So when you get down here and it says a bond was filed in the amount of $20,000, we have a box right here. Would you mark the box sufficient, or would you mark the box insufficient? And I'll go through one more time. Your bond is $20,000 the judge has ordered. Your cash up here is $57,844.59. Would your box be sufficient or insufficient? Anyone could chime in. Okay, everybody's being shy. I'll tell you, it's insufficient. Your bond must cover the amount of cash that you have, and that is the purpose. What is the bond's purpose? The bond is to cover every dollar of cash that you have. So in this case, I would mark this insufficient, and more than likely at a hearing or something like that, or when the court gets this, they may tell you you have to increase your bond to $60,000 to cover all the cash. The purpose of the bond is for the only reason that if somehow, some way, some of this money walks away, disappears, I don't know what happened to it, I did my best, I can't get it to balance, some of it's missing, now I only have $5,000 when I started with 57, but I don't know what happened. Guess what? For $52,000, which would be the difference, they will go to your bond company and get that cash back and put it back into the account for the heirs or the conservatee or the minor. So the bond covers the cash. So that's how you know if it's sufficient or insufficient. Now, the only other way, there's two other ways the bond was waived. A lot of times in a probate case, I will tell you for a conservatorships or guardianships, highly unlikely that the judge will ever let you waive bond. Highly unlikely, because they know what happens. In a probate case, if all of the heirs or adults or all the beneficiaries are, no, in that case it's heirs. But if they all want to waive because they say, oh no, we trust the administrator, he's not going, nothing will happen, it's okay, we'll just rely on them, then they can waive the bond, and the judge will typically approve that if they all waive it. It cannot, so if you have 5 people and 4 waive the bond, but 1 doesn't, you're getting a bond. Everybody has to waive the bond or a bond is being in place. And a bond is only in place for cash. But then again, I have seen cases, and a lot of cases now, where I only had real property, so there was no cash. So initially the probate was applied for with no bond, and the judge has ordered bond, especially. So there's 2 different ways, and oh, my client isn't on here that it's happened to. So we went in and she wanted full authority. There was only real property, so that there was only a deed to transfer. The judge ordered a bond for the same amount of the property because he was going to give full authority. And in that case, full authority means she could, the administrator could change the name on the deed without court approval. And so the court wanted to kind of save the real property because the beneficiaries were children. So he ordered a bond for the same amount of the real property. The problem was she was pro per, so she can't get a bond that's above $20,000 without having an attorney. So she went back and asked for limited authority, which means she can't do anything without court approval, and then ask for a lower bond. And in that case, the judge just wanted a copy of the deed and then approved the limited authority lower bond amount, but it just meant she had to get approval to do everything. So there's a few scenarios here. And then when you get to, or the receipts were put in a blocked account, typically if you have a minor, the court is going to order that any cash of any kind go into a blocked account, which means you are unable to touch it for any reason whatsoever. Once it goes into a blocked account, even if you need to pay a bill or anything of any kind, you have to fill out a separate form, which is a request for withdrawal of funds from a blocked account, and then you need to get an order. So this is quite cumbersome, but I've seen it in cases where, like, we have a probate, they're unable to bond. That typically means the judge wouldn't allow the person to be an administrator, but or they didn't have the funds really for the bond, so they just said, okay, instead I'll just put it in the blocked account and just keep getting approval. But the pain about that is when you have to wait for the time for the judge to actually sign the order. 2, it costs $60 every time you complete a request, and 3, it's just very burdensome, but the blocked account will always happen for a minor. Okay, so now we get down to, again, there's another date place. Your name will go here, or the pro per's name will go here. It will be signed. The example shows an attorney. So if it was being completed by an LDA for an attorney, the conservative would go here. The attorney's name would go here. Again, we went over page 2 of the form, and you have your attachments completed. So now what do you do with this? Your next step is to take all the attachments and this form and you submit it to the court and get a filed stamp right here. And now you are ready for your accounting. So I'll call Rex back in to Rex back in to start you on the accounting. Are there any questions while we wait for him to come in?
I
And
have
may
one.
not- Go ahead, hon.
Okay, I was wondering if annuities and IRAs go on attachment 2.
Yes.
Okay, good. And those don't need to be bonded, correct?
Do they not need to be bought? I'm so sorry, hon. I didn't hear it. Unless you have access and you can turn them into cash, they may need to be bonded. That's the thing. What happens is the court is trying to protect and limit what can happen or how cash can disappear. Remember, if you have the ability to take something, like, yes, a house can be turned into cash real quickly by just doing a sale, but that's a pretty big step. You know what I mean? As opposed to going to a bank and going, hey, I need cash. You can get it in, you know, what, a couple of minutes, right? So keep in mind that what is the judge kind of trying to do? He's protecting stuff from disappearing, specifically cash. If you talk about real estate, that can't disappear. Really, well, if it does, it's really hard to get it to happen. And you have to go through a lot of steps, and you're signing a lot of documents under penalty of perjury, right? So if you really were being scrupulous, let's say you've signed a lot of documents and the court can then, you know, hold you responsible because you're signing the documents. Cash disappears like a little bit different of a way. So I think they go more on what is the ease of you getting a hold of that cash and it disappearing. So keep that in mind also. If it's something like a pension that you really just can't go to that pension, whoever holds the pension, and go, okay, I want, if let's say they had 100,000 in their pension account, you can't just go to them and go, hey, I want $100,000 given to me, and then kind of that 100,000 disappear. It takes a lot of work to get that kind of thing to happen. So the courts kind of feel that doesn't need to be protected as much as cash that can instantly disappear.
Sounds good. So the IRA, if he takes, if we do disbursements to cover his care,
Correct.
and it goes into his conservatorship account, that isn't cash that can easily disappear, correct?
You know, they really will determine that based on the papers that were filed, hon. If you stated like, so the judge will, when you turn in a petition, say for a conservatorship, the judge is going to take into consideration of all of that. And so likely no. But because they know on a monthly basis that cash comes in and out, the hardest part or more that they'll look at is, say, for instance, you say somebody's care is like, well, let's say $4,000 a month. They see that they get a retirement about 2 or 3. They just know that it's almost even. And then all of a sudden you do your accounting and you've cashed stocks of $500,000 and you've turned those stocks into cash. They're going to ask you and possibly remove you for doing something like that. So, and just keep in mind, the courts are watching. They know what to look for. They know what kind of looks like maybe a problem area, and they will make arrangements based on that. And that's exactly why an accounting is due the first year. They want to see what you're doing. They want to see how you're acting. They want to see how things are going. And then even in that case, they will determine whether you're going to turn it in yearly if they think something kind of looks a little funny, or they're going to say, okay, it's good enough. You get 2 years to turn it in again. But that's their only control and their only way that they can watch what's happening. And they're on the best, supposedly, the best interest of the conservatee, even though you feel you are also, they're the second eyes and really trying to make sure that they're not being taken advantage of. Okay, I'm gonna turn it over because Rex has some great information and a lot of it. So I'm gonna leave it to him and I will be back for the petition part. Thank you all.
Thank you, Tamara, for that great presentation. I wanted to clarify one issue before I started on the other subjects, and that is, there was a question raised about IRAs and having them appraised along with annuities. So what you're looking at is either you're going to give it the asset to the probate referee to appraise for you, and that would be in a case where it's indeterminate value, like the cost of a Corvette or cost of a house. Those items go to the probate referee. And IRA ordinarily includes assets that are liquid. So we have a statement from the vendor that determines what the values are in that account as of the date that you received your letters. So that would not be given to the probate referee. And annuities are somewhat of a different animal, because annuities have a fixed amount that goes over a period of time, receipt of income, and then they have what's called a cash value. So the vendor determines in terms of the contract what the cash value of the annuity is. And the cash value on the date you received your letters is the value that you use. The appraiser or probate referee can't do anything about that. So the probate referee would not be offering an evaluation of annuities. Okay, having said that, I'm going to start talking about the GC 400 sum.
So just to clarify, on the annuity and the IRA, those should go on attachment 1 then?
I haven't memorized which attachment. It's on the cash.
On the cash, yes. Okay, sounds good.
Yes. Okay, so I'm going to be covering, well, let me give you a perspective first. We're talking about the inventory and appraisal. So that is the beginning of your responsibility to report to the court. Now, over time, things happen. And as time goes by, there's all these transactions until the end of the year or the end of your account period. And then you do a snapshot at the end. It's kind of like a photograph at the beginning and a photograph at the end of your financial position. And what I'm going to talk about now is in between those two items in history. So we're going to talk about everything that goes on in between and how to report that those transactions. So we are on a form called the GC 400 sum in your material in the lower left, page number 21. And this is a summary of accounts for standard and simplified accounts. Okay, there's two different methods. I'm not going to cover that at the moment. But when you set up your forms, this gives you choice. If you're doing a guardianship or conservatorship, if you're doing a probate, you would write probate. If you're doing a trust that's being reported, the accounting being reported to the court, you would write trust up here. And which account are you doing? This is the first account of many, perhaps. And if you're the subsequent trustee or subsequent executor, I would start over and say, this is the first account from newbie. Okay, but we're assuming that we're doing a probate or conservatorship and we're starting out the opening date of the account, which is the date of appointment, and it's also the date used on your inventory and appraisal. And then through the end of the year. So the inventory and appraisal that we were just talking about has to be filed after 90 days of your letters, okay? And it's a little bit different in probate. Probate, you have to file it within 4 months from the time of your appointment. And for trust, there's no requirement. Generally, trusts don't report to the court unless there's litigation or unless the trustee wants to limit their liability for future claims. Okay, so what we're looking at here is a summary form of all the transactions that happened during the year. Oh, and I point out too that after you do your first accounting at the end of the first year, normally you have to do it every 2 years after that. So it's years 1, 3, 5, 7, 9. You'll be reporting your accounting. Now on the GC sum, we're going to have all kinds of detailed schedules that created these numbers. But you can think of the GC 400 sum or summary page as the axle or hub on a bicycle wheel. So this is the center of the accounting. And you can look at the spokes on a bicycle, and those are all schedules that are going to be created, but they all feed back in to the hub. And that's how this form works. Okay, so first off, we start out with numbers you already have. You go to the inventory and appraisal, you copy the amount of assets on it. You copy the amount of non-cash assets. And I'll cover the meaning of carry value because it's important to understand. So you get an appraisal, let's say a house is worth $2 million on the appraisal from the probate referee. And that is your carry value forever on these types of accountings. Now, there will be times later on, I'll show you where you might need to get a new valuation based on market. The market does not change any of your carry values. They all stay the same during the entire period of your conservatorship or guardianship. So we just copy the numbers from the non-cash on your inventory and appraisal, add them up, easy. Okay, so additional property received during the period. Let's say somebody didn't know that they were, there was another piece of property or something, or an account that was undiscovered originally. Additional property received during the period would go here. The disbursements would go in the lower section. Now, I want to define a couple terms that are relevant here. One is charges, one is credits. And what charges mean is income that came in. In normal accounting, when I was going to CPA school, we would have an income statement, we'd have income, and we'd have expenses. Well, the court can't do anything that simple. So they come up with extraneous terms like charges. But the way to remember this is you're responsible for someone else's money. And that's why you are having court supervision on every transaction that took place. So you can look at charges and think of it as you're charged with the responsibility to manage these assets. This is what you're on the hook for. And if it disappears, the court's going to be after you. So you're charged with a responsibility. Then when you appropriately disperse funds for the benefit of the conservatee in this example, then you're credited from your responsibility. And then that's money that went out that was properly documented. The other thing I point out is, the differences between regular business accounting and court accounting, they're like night and day. And sometimes conservators or trustees will hire an accounting firm that doesn't understand the difference between court accounting and business accounting. And it causes a big problem because business accounting turned into the court will be rejected. Not only that, the trustee will have to pay out of their own pocket for hiring someone that didn't know the proper procedures. And then they're going to have to hire someone else again, a duplicative cost to find someone who knows how to do the court accounting. So this is just a nature of from the California Probate Code. The other thing that occurs is when you go to accounting school, we start out with debits and credits, and they're used throughout the transactions in a regular business accounting. There's no such thing as debits and credits in this type of accounting context. So if you happen to have that memorized, it's not going to do you any good here. Okay, so these totals with schedules are in fact several schedules compiled into one number. And we're going to go through each of the schedules in detail. You'll notice that there's zeros on the blank lines. And as the form points out, zeros, you have to put them in because if you leave it blank, the court might ask, well, did you just forget to put it in? And by putting a zero, then you've made an affirmative assertion. It's zero. And so that's one of the requirements on this form. Now, in the upper right of the form are the form numbers, judicial council. You can call it up on the internet, do a search on California Judicial Council forms, and you'll see all of them. And these guardianship and conservatorships, that's what the GC stands for. Okay, and then the form number. In the lower left, it says adopted by the Judicial Council for mandatory use. So it doesn't matter what type of accounting you're going to do. If you're doing an accounting that's going to be submitted to the court, mandatory, you must include this cover sheet. Even if you have a summary that might be an Excel worksheet that looks just like it, you're still required to include this form. So here's the beginning numbers we talked about. This is all the money coming in, and we get a total. Now we talk about the money going out, and we get a total. And then at the end of the account period, we list what we have left over. And these numbers, the 14,404 and the 14,404, need to match. If not, you're not done. And for tax purposes, we do a lot of income tax. The IRS doesn't want pennies anymore. It's just not required. Pennies are worthless anyway. But the courts are so retentive that you have to track every penny. And that's why it's listed here. So we talked about carry value in the beginning. And then at the end of the account period, you see we have carry value again. And when you're doing on the inventory and appraisal, you have asset numbers listing asset number 1, 2, 3, 4, 5. During your entire time as a court accounting reporting person, keep those asset numbers the same. Even if you sold asset number 7, just don't use that 7 anymore, but don't change your numbers of your asset numbers on beginning or ending inventory and appraisals, because you'll make it difficult for the judge to be able to track assets over time. Okay, so we're talking about the required forms. It says probate, guardianship, conservatorships, mandatory use. Now, trusts, when trusts report to the court, they have a similar set of rules, but when you're reporting accounting for a trust, this GC 400 sum is optional. If you want to use it, fine. If you don't, they're not going to reject your account. If you turn in anything that does not have the GC 400 sum, get ready for it to be kicked out by the court because they will not process it. The other item is consistency. The courts will always use, they'll take the beginning numbers and the ending numbers, and the next accounting, they're going to go right back to the ending numbers and see if your beginning number on the next year matches. And if it doesn't, they're not going to process your accounting. So we're going to get into the details here of how all these summaries come together. And you might even want to tab this page 21, because we're going to be working at subparts or spokes of the wheel. And then we're going to keep coming back to this summary of account. We just call it GC 400 sum. Okay, so this is really redundant in the first year of accounting, and that is assets at the beginning of the account period. Well, gee, this looks a lot like the inventory and appraisal. It is. It's the exact same information, but you have to include it because if it's year 3, 4, 5, whatever it is, they want to have you include these forms each time. So there's your asset numbers we talked about and the values from your inventory and appraisal. One thing that is, we've seen it happen, I just pointed out that we had one case where there was one spouse who became mentally incapacitated, handicapped, and the other spouse had filed for the conservatorship, and the way the papers were written, the spouse who was still managing the asset was required by the court to do an annual accounting. And when we saw it, I objected to that because if all the assets are community property, either spouse has an unlimited right to manage that property. And so as part of the probate code, 3051, if that situation occurs where one spouse is well, the other one's incapacitated, you do not have to issue an accounting as part of that conservatorship each year. It's just a waste of time, effort, and money. Okay, so we're still starting out at the beginning of the account period. And we went to the cash, and here this is second part of it, called the non-cash assets. And it looks very much like your inventory and appraisal. We're still at the beginning of the account period. And it's basically a copy job again, same asset numbers, same carry values, fine and dandy. In the first year, you do not have to fill out this column called estimated market value. You would be filling that out in future years. So if we were doing, let's say, the fifth accounting and there's real property, you're not required in subsequent years to get a new appraisal every 2 years or so. But what we do in this case, let's say there was a property and you came up with a Zillow estimated market value, that's close enough. And it's always going to be different than your carry value. So, and that's pretty lax. Okay. So much for the beginning assets. It says footnotes that we discussed. Now we're getting into a summary sheet. We talked about the bicycle and wheel and the spokes. this is heading towards the middle of the hub and the bike, and it is a summary of multiple sheets of paper. I like to think of them as links. So if you had dividends, this total, there might be 6 pages that comprise the dividend list that we're going to cover, but all of them total together with dividends and are entered here. This is not required to be filed with the accounting. I still would use it because you have one summary sheet with all the activity, and you have all these detailed schedules, which can be voluminous. And this particular schedule will summarize each of the sub forms and make it easier for people to follow. So you'll see the form numbers here. We'll have 400 A1, A4. So these are all subschedules. You'll see what I mean. And here on the disbursements, we have 400 C, C8, C7. Anyway, this is a nice interim sheet to help everything balance, and then you bring your total for the Schedule A onto your GC 400 sum under Schedule A. I end up referring to this as Rex's favorite form because it's useful, allows me to trace data, but technically the court says you don't have to turn it in. Okay, so now we're getting into the weeds. We need to track every bit of income that came in to this, I'll just call it an estate, whether it's a guardianship, conservatorship, or probate. And you list every transaction. So in this case, we've got dividends. You cannot summarize all the dividends for a period. You have to list every dividend on that broker statement, unfortunately. And I generally break it out by vendors. So there might be a Charles Schwab, Merrill Lynch, and just list them item by item, take them right off the broker statement. Now, there's a kind of, let's say you're working with investments, they got a portfolio at Merrill Lynch, and it had already been set up before you had received your letters. And you notice in the statements that every time there's a dividend, the broker turns around and buys more shares. It's called a dividend reinvestment program. And the initials for dividend reinvestment program is DRIP. And when there's a dividend reinvestment program, as a person being required to report transactions, it's not good for you, because on each of those little dividend items, first you have to report the dividend. Then you have to go back and treat the reinvestment as if they purchased stock. So you've got double the work for every little transaction in a dividend reinvestment program. So to avoid that kind of unnecessary work, I suggest contacting the broker and asking the broker, don't reinvest the dividends. I want you to take all the dividends and put them in cash. If that's the case, when you're listing your dividends, you do not have to go to the schedule to show you bought more assets, and it will save a lot of work for you. Now, in stock brokerage reports, you might have a mix of fair market value and cash transactions. So the dividends that are showing here are the exact amount of income that was received. There may be on that broker statement market values. You can't consider any of those. because at this point, for the rest of the schedules, market values are not allowed to be listed. Now, this next concept is a little detailed. If you are getting dividends, normally dividends are just cash dividends, no big deal. But sometimes you'll get a dividend that'll say capital gain distribution. And although it's frequently done, it's not correct, but taking a capital gain distribution and putting it into the income on the dividend schedule. What a capital gain distribution, it is in fact additional principal going into this accounting. So it's not cash income, it's additional property received. And just for vocabulary purposes, I'm not going to use them. When you're dealing in this area for assets in a trust or in a probate, they frequently say the principal of the accounts, or sometimes you'll hear the word corpus. So don't be surprised by that. But the point that I'm making at this section is that if you get capital gains distributions, you end up having to put them in as principal, not as income. There are, you'll see that there's a lot of different forms, more than you're going to ever need. There are, in fact, 48 different types of income and disbursement forms in the court accounting. And if you get some kind of transaction that is unusual, you might need to consult that list of 48 forms to find one that matches up with the kind of transaction that you're involved in. Okay, so another feature of these forms is the subtotal feature. So we're on a schedule A1, and it says we're a subtotal, but we're not done yet. You'll see down here, this form is designed so that we know we're on Schedule A, and this is the first of 6 Schedule A's. Another thing that you need to be aware of, and it's a common beginner error, is that they accumulate numbers from one page to the next and continue to grow the numbers. It'll never balance. The way these forms are designed is you do a subtotal for each page. You do not accumulate any numbers onto a subsequent page. Let's say if we were doing a second or third 400A1 and we had 3 of them, each of the 3 attachment pages would all have subtotals not accumulated. Okay, so we're going on to page 24, receipts. Interest, simple. Just list each interest from the bank statement. I would list each of the accounts separately by name of the vendor. And there's, when it says amounts, I think this is a misnomer. It says amounts, it really should say income. The way that the accounting works is we have a lot of subschedules leading to one big schedule. And I compare this as kind of like a river. So we have rain up in the Sierras, and we have little creeks, and they get bigger and they turn into rivers, and then they get into the bay, and then they're washed out to sea. And that's kind of the way that this accounting works, with all kinds of subparts leading to one centerpiece. Okay, receipts, pensions, annuities. It says regular or periodic payments, standard account. There's another type of accounting. We're only talking about standard account. And I'm not going to cover the other type. And there's another called simplified account. And that's if you have very few transactions, like 1 or 2 pages only for the entire year, which could happen. And in that case, the court allows you just to list the transactions, and it would appear like a checkbook register. Well, the money coming in described, money going out described, and it's a simplified account. I don't recommend them. I don't teach them. It's just a nuisance. But if you have very few transactions during the year, you might look into it. I personally think it's easier to use the standard account. So just take the broker statement or the bank statement, list all the receipts, pension, annuities as you receive them. Okay, rents. In terms of rents, what is needed here, say if there's 2 rental properties, you would list 1 rental property and then all the transactions of income. And then the other rental property and list all those rents received during the year. And you need to avoid netting of transactions. And by netting of transactions, let's say hypothetically you have rental income on this property and the tenant says, well, I can fix the porch for you for $400. You say, okay, you fix it, take it off the rent. Well, I wouldn't do it that way. I would tell the tenant, okay, you fix it, give me the rent in normal $2,500, and then I'll write you a check back for $400. For the accounting, that's much better. So if you were just to write this as $2,100, you've netted an income and an expense, and you don't net any transaction in the accounting reports. This schedule is used for what I call passive rentals. You just have rental income month to month, year lease, whatever it is. Now, there are other types of transactions that sound the same, they're not. So what we're talking about here is passive rental incomes. If the property is really, in fact, an Airbnb, short use, or hotel, or a bed and breakfast, you would not list the income here. There's another section that you would use for operating a business. And I'll go back to the GC 400. And you'll see here, income from a trade or business and loss from a trade or business. So this is actually helpful because let's say there's a certain type of business being operated and there's an accounting firm on doing the books for that business. You as the fiduciary do not have to report all the income and little transactions from the business. You just get the income statement from the accountant and you put the income or the loss one time and not with all the details. So that saves effort. So let me go back here to page 21. Okay, so we're on page 27 on Social Security receipt, other pensions. Okay, we had a probate examiner take our class and she noticed immediately there's an error on this page. As I mentioned previously, you have to list every transaction as it occurs during the account period. And you cannot combine or just write the end of quarter totals. In this example, they're including 2 months or more of the Social Security payments. And you can't do that. You have to list every item that was received and the date received. Now, this gets back to the netting. I told you netting before in the example of the tenant fixing the porch. And this is still not changing the netting rule, but it comes at it a different way. Okay, the netting I talked about previously were transactions under your control. Now I'm going to talk about a different form of netting for transactions not under your control. So Social Security automatically deposited in the bank every month. And Social Security subtracts, like payroll taxes, they subtract Medicare Part B from the Social Security before you get it. Okay. You do not include the total amount before the Medicare. You only report what you're responsible for. And that is the net amount. So it really doesn't matter what Social Security Administration took out before you got access to the funds. Okay, so we're in other receipts. We've got miscellaneous receipts. If it didn't fit on one of the other forms, you can list them here, give detail. You want to give enough detail so that the probate examiners and the judge can see what kind of transaction and understand that, you know, the money's not just disappearing. So I was talking about previously about not accumulating numbers page after page. So we were on GC 400, sum, Schedule A, and now we have all these subparts, and now we're on page 6 of 6. We're going to be leaving this income section. And at that point, we will bring the totals back up to the summary schedule. So we're done with Schedule A. So you list each of the subparts here on the summary schedule, and then you'll get a total for all of this type of income. And then you will bring it forward to the GC 400 sum under the description of Schedule A. As you're going through the accounting for the year, you might end up adding additional schedules that are not identified here. I recommend that when that happens, and it's quite appropriate, but instead of continuing the letters, these new schedules that you're labeling, I would give them numbers rather than letters. It'll be easier for the examiners to trace your data. And the reason for that partially is I was thinking of continuing using these letters. And then when I got to the bottom, I found out, oh, I was going to use Schedule E, and it already existed. So it just reduces some of the confusion if you label new schedules with a numeric number. Okay, we talked about miscellaneous already. Now, gains on sales. We're entering into a different kind of transaction here. We sold something. We happen to sell a house. So we list sale date, single family home, and then we go back to our carry value and we see that it was 230,000, fine. And then we have sales price, and then we show a gain of 19,000. Well, this sales price is what we call the offer price in real estate. I also have a real estate broker license. It's the offer price, contract price, but you can't sell it for that because you have all kinds of transaction costs. So my view is this is very misleading. You have your carry value appraisal when you started. You have the sale price, which is just the contract price, and you've got another 30,000 or so expenses that don't show. And they're trying to say that this is the game. It's not the game to me. However, you have to do it this way. And we will cover later the expenses that you'll pull from the escrow statement. And always use the final escrow statement on house sales. Normally what people give me is a preliminary closing statement. And that's not good enough because it might change. So you want the final. And because this house is sold, this is an item from your beginning inventory and appraisal that's going to disappear in future years. And I would not use that asset number again, just have it disappear for future years. Okay, so we have a house sale. Other disbursements. This is residential care items. We have one client that pays about 150,000 a year for a room and board. It's amazing what it costs in skilled nursing facilities, but you just list what the items are. Sometimes what we'll do is if there are other charges like haircuts or trips, different things, we'll put those on other schedules and just show the base rent at the skilled nursing facility. So you'd end up getting a statement every month, or it might come out of a checking account. It might be an automatic transfer. You can pull the data from that. So at this point, we're in this accounting, we have switched to the disbursements. Before we were on the income items. And so we started the disbursements going out the other way. And the other next expense are general administrative expenses. You would just list them and describe what they are. A conservator, guardian, or probate executor cannot receive any compensation during the year until approved by the court. And that also includes attorney's fees. You have to wait till the end, you get it approved by the judge. So here you're just listing quite a few things. Here's our probate referee's fees for appraising the house and other items. There are other kinds of transactions that you might want to become aware about. And that is when you're appointed a fiduciary, guardian, conservator, executor, you're a fiduciary, and you're also going to be responsible for preparing the tax returns for the ward, the person you're taking care of. And what the IRS has you do is you prepare an IRS form 56. It's notice of fiduciary relationship. And let's say you're a probate administrator, you would fill out the form 56, sign it, and then with your letters, when you're appointed, you would send that to IRS so that IRS knows that in the future, if there's any government letters, that they should send them to you. And when you're doing tax returns for your ward, the way that you sign the tax forms is you sign the ward's name in cursive writing, and then you put by, and then you write out your name and your title. Conservator, executor, and that's how the tax returns are filed. Another thing that I suggest you do, a procedural matter, I came from old school. I have adding machine tapes. I still use them. I like them because I'm so habitually tied to them. But, and there's not that many of them anymore. You can hardly find them. But the concept's the same. Every time you add up a series of numbers doing the court accounting, I suggest that you go back through and look at your numbers that came up with the total you're going to write down. So you always do a double check. And the reason is, if you hit a wrong key and used that total and did not find out that there was an error in your addition, then you're going to have an out of balance situation. And you can waste untold hours trying to find errors in a court accounting. It's a real nuisance. So my suggestion to that, let's say you're using your cell phone or a computer adding machine on the screen, it'll show you the details of the keys that you entered and verify that back against the source document before using the total. If you were to write, pay disbursements out of your pocket, you turn in the receipts and then treat it as a disbursement. Okay. Tamara says I need to speed up. Fine. We have the next item are living expenses, disbursements, miscellaneous items for the ward. Just describe what it is. List them sequential. And I wanted to cover some of the errors. One of the problems that come up, let's say you bought 20 sheets and the court says, what are you buying that for? And it turns out that the ward is incontinent. Well, you can describe that so you don't get questions from the probate examiners. And here are some common errors you want to avoid while you're doing court accounting. Accounting for asset which you have no responsibility, confusing responsibility with value of the asset, confusing fiduciary accounting with other types of accounting, using one line item to bring your accounts into balance, sometimes called a fudge factor. You can't do that. Missing data, an error making checks out to yourself without court approval, and an error making payments to the fiduciary before the beneficiaries. I want to tell you about a reference book. It's not for pleasure reading. It's the Fiduciary Accounting Handbook, and it's by Continuing Education of the Bar. It's about a $300 reference book, but sometimes you need to look up some unusual transactions, and for the $350, it might be worth it. Okay, so now we're listing disbursements, medical expenses. We talked previously about the escrow. Here are the escrow costs, all listed under disbursements. Here's an expense. You sold some property and you had a consignment fee. You just show what you paid. Disbursements for rental property, you do not list it like a Schedule E on a tax return. You list them item by item.
One of the questions, which is up here, which is really good, I want you to go over, is she asked, what if there's joint accounts? You have a conservative, might be the wife, and there's joint checking accounts. How do you account for the husband or?
Okay, to rephrase the question, what if there's husband and wife, one of the spouses is mentally handicapped now, Alzheimer's or whatever, and how do you treat the account? Okay, as I said previously, if all the assets are community property and the other spouse is in managing those assets, they're not even included as part of the accounting. So community property, you would not be showing them with a couple that has long time assets. If the account, let's say the couple recently got married and it's not community property, and it was the ward's asset before they got married, then it's a question whether it's community or not, but I would assume it's separate property. And then you would account for each transaction as it occurs. Okay, so these are miscellaneous expense. List all the items that you are not able to find another form for. This is an example of stock sales. Well, this is a car first. Just like the house sale, carry value, sale price, and gain. Then we're getting into cash on hand at the end of the account period. So now we're at the other end of this year or 2-year period. Now we're reconcile all the way out to that ending date and just list the reconciled values. Non-cash assets, these two schedules at the end of the account are very similar to your inventory and appraisal. And here at the end of the account period, we have estimated values. Don't worry about it. You're not going to go to jail if you go to Zillow and say the house is worth 1.1 million. It's not. Don't worry about it. But your carry value is not changing from your beginning values. I point out something else, that if you want a certificate of completion from this class, that's very nice. You can email us and we'll send you a certificate of completion. Okay. The next item I want to share with you is in your material. And it is handout number 2. And what this is, instead of filling out the government forms, this is done on Excel or another program. And this is another way to do court accounting that's a little bit different. This summary of account follows the GC 400 sum. And I think this particular accounting is a work of art. So we're listing all the disbursements as property on hand at the beginning, inventory and appraisal, and then the receipts chronological. And then we have the receipts by category. Very nice looking report. And it's in your materials if you want to try to follow it for use on Excel or something. We also sell a simple Excel template. And then receipts during the period. Anyway, you can look this over and you might like doing the accounting that way. If you do it that way, you still are required to use the GC 400 sum. And with that, I got to go back to the tie it all together for you before I let Tamara take over. And
Just a real quick question
go
on
ahead.
that Excel. So I'm entering everything into QuickBooks by transaction out of the account, and I can print reports just like you just showed me. Is that something I can use instead of the detailed GC 400?
The word GC 400 is multifaceted, so you cannot use it for the GC 400 sum.
Right.
You could use it as in that other court example for chronological.
For the detail.
Yes.
Okay.
But you have to, the way that other one was accepted, it's not just a QuickBooks report. I don't know. I'm hesitant to say that you can use just printed out QuickBooks in any manner for court accounting. It's good for chronological, but that's about it. If you don't have the categories. I think about designing something like that, but I've never done it. So I need to summarize what we've done so far. We've listed all of the income by schedule, and we have the beginning inventory and appraisal plus all the income detail. Then we went through disbursements, and we just went through the last 2 pages showing cash at the end, carry value at the end, and we have a balancing report. And if it isn't balancing, don't bother turning it in. So again, this GC 400 sum is like the hub of a bicycle wheel, and all those other schedules that we've been talking about are like the spokes. So this is the end of the numeric part of the explanation. I'm going to give it over to Tamara now to talk about the petition that needs to accompany your accounting reports.
Thank you. Just don't steal my coffee. No, I'm kidding. My tea. Hi, guys. I'm back. I wanted to answer just the question about QuickBooks. I use QuickBooks quite a bit. You asked about you use that instead of the forms. I love QuickBooks. I use it for everything. I use it very often. I know its capabilities. I know it, how it works and how it keeps track of things. I myself do not believe that there are a few transactions you could do, but it wouldn't complete the accounting. And I'd specifically go into like stock sales and stuff. You'd have a hard time trying to get that into a QuickBooks because you don't have both sides of, you know, kind of, and that's not something you enter in. So I don't know, I'd shy away from that and basically use schedules, but that doesn't mean you couldn't enter all your data into a QuickBooks or a Quicken or something like that, and then print reports and then take those reports and re-enter the data on the appropriate schedules. The other thing about QuickBooks, I guess you couldn't get in, like the court examiners want to see like a little bit more details. So I mean, I guess you could use them both, but you would still end up throwing them into a proper schedule. Just my experience and how I've seen a few things kick back from the court and the processing and correcting. Okay, so I'm going to go and I apologize, but I need to slide the screen a little bit because I can't tell where mine starts. It's in a different order, so I'm gonna, I think I'm starting page here. And for you all who's looking at it, it's number 11. Move the screen a little bit. I couldn't see it that far away. So, okay, so this part is you've completed the accounting and you need to turn it into the court. You cannot just submit your accounting, as you could imagine. And I won't go back to the accounting page because I don't know if I can find it, but there's no place to do the filed stamp. There's nothing they would understand of you just turning in the accounting report. So the accounting report must go with a petition. And for those of you who are doing pro per, you go, okay, what is a petition? Well, or what is the purpose of it? The petition is overall just a summary of what happened during the account period. Plus, there's a few other things that you will be adding in there, and you'll be able to see that as I go through. But the real purpose is really you're saying in a very polite way, Your Honor, this is what I did. I've submitted all the accountings. You can see it in a particular order, and I wish your approval and acceptance of this accounting, and then I can move on. I will tell you one of the main purposes or why it's mainly done is once the judge approves it, that limits your liability. If the judge approves it, it's good, you're good. Now, that doesn't mean that one of the beneficiaries' heirs can't come back and say, they only have a short amount of time to come back and say, I don't agree with something like that. They should actually do it before the hearing, because this will be sent to all of the beneficiaries or heirs prior to the actual hearing. They will have enough time to review it. What I have seen is usually if you have beneficiaries or heirs who do not believe it, or do not feel it's honest, or do not feel it's appropriate, they will hire their own counsel, and there will be an objection to the accounting. That doesn't mean more or less. So there's two different ways, and I'm speaking to somebody who just prepared it. That has nothing to do with you, and that's not your responsibility. If you're the conservatee, the guardian, or the administrator, it may require an explanation. So things I've seen, or what could happen is, let's just say, okay, I'll give an example. I was completing one for a client, and there was quite a few line items that were like, and I'll just give a simple one. So it's a conservatorship, so of mom, who is older, and there was a McDonald's charge for $86. I myself instantly, because I've done this for so long and so much, said to myself, oh no, the court, there's no way the judge is gonna look at that and say, okay, that's conservative, went to McDonald's and ate $86 worth of food, right? Because you got to remember, these expenses are only for the conservatee. So I said, this is going to be something that's questioned. Believe it or not, I saw the examiner notes. First thing they said, please explain. Or there could be an objection. Really, what happens after that would be a declaration by you if you didn't put enough details. So a lot of times when I do accountings and I see stuff like that, I will say, and this is how I ended up, it was one of the ones I needed to correct inside the accounting, so that I didn't have to kind of do the declaration, although I did both. But inside the accounting, where under the foods, it was McDonald's, took conservatee, went with, and I think she had 5 or 6 grandchildren. They went to the zoo first, went to the zoo, and then after the zoo, grandma wanted to purchase, just take them to McDonald's. So this was a one-time thing where she took her and 5 grandkids, how many of her people, to McDonald's, and yes, she did purchase it. But mainly they're looking at, there's no way, and then the other things that I had to explain, but thankfully it was around Thanksgiving and Christmas, is there was Costco food that looked a little bit extraordinary. So it was Costco food, 300 and stuff like that. I kind of knew what it was, even though the conservative didn't tell me, but I cannot do anything about that. I must ask every single question if I'm a preparer. And I did find out that it was one of those cases where the conservative every single year is the one who hosted Thanksgiving dinner for her family. Just because she becomes under a conservatorship doesn't mean you're supposed to go through and completely change her life and make her isolated or anything like that. Even though she doesn't have the capacity really to make good judgments, doesn't mean if she decides she still wants to have her family over for Thanksgiving, she's not allowed. She was the cook and the preparer, and maybe she can't fully cook or prepare, but that doesn't mean the joy and the love of having her family over and her at least helping prepare that meal needs to change. So when I did see an expense like that, I did write in brackets or details, Thanksgiving dinner, conservatee was always the cook and the planner and got the family together. And so make sure you write those details in. Don't wait for the court to ask you. Be proactive and write those samples in there. If something like if you're a conservator and you have a conservatee and maybe there was something you see in there that might require an explanation, then put the explanation in. Don't just let it go because it looks, because again, then you have the problem with what if one of the heirs or the beneficiaries make an objection to that, and then you're talking about trying to almost litigate a case. Whereas if you would have put the example in, so they would have seen that, they probably wouldn't even have objected. A lot of other times, if there's an objection to your petition, you may have to file another petition on top of that to state why you did what you did, and you're going to have to explain yourself. And then the copies of that has to go on. Your court case is going to go on and on and on and on. So to alleviate all of that, try and put examples in. That's my only thing. So we'll start with the petition. The petition must be on pleading paper. It's a requirement. Pleading paper can be found all over the internet. What is pleading paper? Pleading paper means it has numbers along the sides along here. You can do a search on the internet for, and you call it pleading paper, and you can find copies anywhere out there. So on top of the pleading paper, this is kind of reserved. This is attorney information like our inventory and appraisal, but instead this would be just your data if you were preparing this yourself. So up top, Tamara Brown, my address, 3000 Citrus Circle, Suite 207, Walnut Creek, and then I give my phone number and again the email address. And instead of attorney for, you just wipe all of this out, and it would be Tamara Brown Proper. Remember down here, this is the court when we were filling out the inventory and appraisal in the center portion. Remember I told you what's a court. So basically you're just typing in what county of the court. In this case, you will see I have conservatorship, and this is really important that you state what it is. So conservatorship of a person, I wouldn't be doing in accounting. Conservatorship of an estate, yes, I would be doing accounting. Conservatorship of a person and of estate. So this means making medical decisions for the person. This means making legal decisions for the person. Can the person get married? Other legal decisions. This means I'm only taking care of the person. So really, you have to pay attention to what it was asked for on the petition or what you were granted by the court. So again, if you only have a conservatorship of a person or a guardianship of a person, you would never be doing in accounting because you're not responsible for any money. Anytime it includes the word estate, then you're responsible for money, then you need to do an accounting. So in this case, we have conservatorship of the person and the estate. And we have the conservatee. Some people may also know her as, she goes by her maiden name. She goes by her new married name. You know, it just, this can be just to identify the conservatee. And then we've indicated they are the conservatee. So this could also be the decedent. It could be the minor. It could be the conservatee. So it would all be dependent on what your case is. We would put the case number up here. And then in this case, we state it's the first account and report of the conservator. It's a petition for its settlement, which means judge approves it. Approval in this case, when Rex went through his example, there was an approval of a sale of a property. This is where you ask for a conservatorship fee if you wish one or desire one, and we'll go through that once we get down to that section. And in this case, there was an attorney, so they put in the attorney compensation. So anytime you have a conservatorship, a probate, or a guardianship, an attorney does not get paid until this petition is turned in. So a conservatee who has worked, that's the only thing is, yes, your accounting might not be able to be, it's not due for 2 years, but remember, you don't get paid for 2 years either. So if you're, using this and counting on that income, don't. So it's kind of more or less you being, just the good person you are. Okay, you need the date of your hearing on here. You may not know it, but you would still put date of hearing and leave this blank so that when it's turned in or filed with the court would stamp the hearing date, and they will stamp the time and the department. I never put in the judicial officer. And the reason that I always leave it blank, even if I know who the person is, and that is because of the fact that you don't know if that judge is going to be there that day. You don't know if there's going to be a commissioner, if there's going to be a pro tem, if it's going to be, you don't really know who's hearing it. So I like to leave that blank, and sometimes they fill it in and most of the time they don't. But then after this is filed and you get this back, you have to remember this is what you're serving to all the parties to provide them the date and time of the hearing and the approval of your accounting. So that will be filled out, and up here will be the whole filed stamp on here. Okay, so what is the petition going to say? So the petitioner, that's you, and in our example is David, hereinafter. So this just means from now on, when I refer to myself, David, I'm just going to say conservator. I'm just going to use the words. So that's why this is put in here. So it says, as conservator of the state, I present for settlement and allowance this accounting, and I respectfully state. Okay, now it's always the first thing, the appointment. So you're telling the judge, you're giving him a summary. You never want to have the judge have to go through a file, and it used to be right now where every court's getting this electronic filing, so they're getting much more sophisticated with their system. But it used to be that the judge would have to go through, I mean, you can imagine your file that's in, I mean, pages and pages, and then try and figure out when you were issued your letters and do I have the right page? And they just don't have time for that. So right here, what you do is you state your appointment, and then they can verify by looking at your accounting if your accounting is within the proper period. But this tells them a lot of information. When you got your letters, when the hearing was, and stuff like that. Second is you will state on here inventory and appraisal. So I'm stating here my inventory and appraisal was returned and filed this is when I filed it and what was my total value on that inventory and appraisal. So in this case, it was 1,342,000. What do you think that judge is going to do? He's going to go directly to the accounting and make sure your starting balance totals 1,342. If it doesn't, he doesn't even need to look at the accounting. He rejects it in its entirety and says, something's wrong, it's got to be fixed. Right? They don't even waste their time. They know that quickly. So that number should correspond with your accounting. Here we go down to the next one, which says account period. This account period covers, and it states what it covers. In our case right here, it only covered 1 year. And sometimes it will cover 2 years. So it's just dependent on what the accounting period covers. Then you have charges and credits. So basically, you learned from Rex when doing the accounting what they call charges and credits. Credits income, charges most time expenses. So the conservator is chargeable and is entitled to the credits respectfully on the summary of the account and those schedules. So basically they're saying take all of the schedules on the accounting and approve them. I am responsible for them, but review them and accept them. Now, a lot of times, let me just tell you, there'll be a few things that could happen. The court could accept the accounting. The court could, hey Rex, an accounting can be accepted, approved, and what's it called when it's not necessarily approved, but it's accepted? I think that.
Okay, yeah, the two statuses are approved and accepted. Approved means the judge is signing off, it relieves liability of the fiduciary. And accepted is the example of, yeah, we accepted it, but it wasn't quite as good as we thought.
So there could be two different, there could be, so approved and accepted. A lot of times it will be accepted, which means they don't necessarily agree with a couple of your expenses or whatever, but they're going to go ahead and just push it through because it was good enough. So that is that. Now we get down to number 5, which says authorized investments. During this account period, all of the cash has been invested and maintained in interest-bearing accounts. That's extremely, extremely important. Let me just tell you, we have long ago had a case where a conservator put money or put the conservatees accounts into just a regular checking account and then just use that regular checking account, but it was a significant amount of dollars. So later on, one of the beneficiaries actually sued the conservator for the interest that was lost. And basically what they argued is that you as the conservator did not maximize the asset. So what does that mean? Put it in an interest-bearing account. So the person who sued the conservator actually won the case, and the conservator out of her own money had to pay that interest that the money would have received had it been in an interest-bearing account. So always make sure the conservatees, the minors, money is in an interest-bearing account. And even if you're doing a probate, you want to make sure it's in an interest-bearing account. Yes, I laugh and argue. Most of the time, my clients, even with a large amount of money, get like 10 cents or 12 cents. And you're like, really, is it worth the hassle? Yes, you need to do it. Okay, so statement of liabilities incorporated with this petition. I've included liabilities. In this case, there's a lien, which means there's a mortgage. So I want to indicate there's a mortgage and there is a little liability owed by the conservatee. But I also state there are no taxes that are due but unpaid, and there's no judgments for which the estate is liable. Now, I'm going to go further into, I've been really bad on prior recordings or prior classes where I have actually told people that some of these line items will not apply to you. So if they don't apply to you, don't use them. I was an absolute error, because upon the review of my accountings that were, or not my accountings, but somebody else's accountings that were rejected, one of the things is I went to the petition to look at the petition, and it was so funny when I actually meant that statement. Like, I meant, if you did not sell an automobile, you will not put in your petition sale of an automobile and then state I did not sell one, or they didn't even have one. Then sell of furniture, if you don't have it, so skip it. And I didn't mean, though, these other important topics, if you don't think they pertain, then don't put them in there. That's not what I meant when I said that, but that's what I guess I gave off the impression. So there are only a few of the items that you cannot include in this petition, and number 7 would be one of them. Again, the example in Rex's accounting was a sale of an automobile. And say you don't have an automobile, but you sold something else, tools, you sold, I don't know, paintings, or you sold something else, then you would indicate in here whatever that item was. As you will see on the petition, that it says it was originally on the inventory and appraisal, attachment 2, so that tells me it was a non-cash asset. It was item number 7, and it happened to sell for a loss. So what does that mean? So the probate referee, say, let's not use an automobile. Well, we can use the automobile. A probate referee valued at $10,000, but the probate referee didn't know that the entire back end of the vehicle was crushed and demolished, because I didn't say it. And so there's no way that that vehicle could have sold for 10 grand. So instead, though, I knew the conservatee would never drive again. I didn't want to pay the DMV fees, the car insurance fees, and all the other fees or expenses I'd have to pay. So I decided to sell the vehicle because I knew she was never going to drive again. What I would state here is that, yes, on the inventory and appraisal, the probate referee valued it at $10,000. I had to sell it for a loss. For what reason? It was completely damaged. It was oxidated. It had not been maintained. It sat for a long time. The battery was dead. Well, you couldn't just use a dead battery. Whatever the purpose, somebody left the car door, which we think it was a conservatee, left the car door open the last time she was in it, and it rained for 3 seasons. Nobody noticed, so the entire inside of the car was rained out, or, whatever the reason indicated, especially if it's a loss, you will be questioned immediately. Now, if it's for more, the likelihood of you giving a detailed explanation is nothing. You don't need to, as long as it's for more than it was appreciated for. but you would still put it in here if you did so. Same thing we have with furniture and fixtures, exact same thing. And you can read from the description how it was sold or what it was sold for. So now the next thing is they sold real property. Most of the time, again, it wouldn't necessarily be the conservative's home unless you have a lot of expenses going out. But in particular, a vacation home, you really wouldn't need to keep a vacation home. One, say for instance, the conservatives under 24 hours, 7 days a week care because they are unable to care for themselves. The likelihood of you getting much enjoyment from this vacation home or the conservative, not you yourself, is very slim. So there's no reason to really hold on to it. And say, for instance, you need the money for the care facility she's going into or something like that. You can sell the property. You just need to state that you sold the property and what was the purpose. And here is the reason why. Now we get down to talking about bond. In this case, an additional bond, is going to be required because at the time, at the beginning when we were talking about when does the judge issue a bond or state you have a bond. So say for instance, you got a minimum bond, $20,000 because your cash was lower than that. But now you sold the vacation home. So you got $183,000 from the sale of the home. And maybe you got more than that. I'm not really reading this. But again, you increased your cash that can walk away by almost 200,000. Let's just say 200,000. You're going to either do it yourself ahead of time and tell the courts, okay, I went ahead and increased the bond, or you're going to tell them they may want to increase the bond, or you would say my bond, if you want to let them make that determination, you could say my bond is insufficient for the cash I have now, or you can say something like that, but you will want to talk about or bring to the attention of the court that your bond is much lower than your cash at this point. Okay, going down, number 11 must be on every petition, and I can't say this enough. And again, those 3 accountings that I corrected myself did not have this on the petition. You must include this. This is very important and it must be there. No affiliate relationship during this account period means I didn't hire an agent who was a family member or relationship to the conservator. So it's okay if you, so in this case, we said we didn't hire anybody, but it is okay if you do, as long as you disclose it. And I'm gonna give you 2 separate examples real quick so you know the difference. So conservative has a house, but maybe they're staying now for a temporary time in a care facility because maybe they had a hip operation and maybe they need to stay at a rehab center for a little bit just to, build their mobility. So they have the house, and let's say the gardener tells you, I'm going on vacation, I'm going to be gone for a month. So the gardener's going to be gone for a month. I'm going, oh geez, the grass is going to grow, I can't let this happen. What am I going to do? I've got to go out and search for another gardener, blah, blah, blah. All of a sudden I'm sitting here thinking, and I go, oh, hey, it's summertime. I have kids that were home from college, or let's say I have a high school son, and he can do the gardening for a month. And let's say the gardener comes weekly and just mows the lawn. So it's not a huge task. And I know my kid knows how to mow a lawn. So I tell my son, hey, I need you to do me a favor. I need you to go mow the lawn of the conservatee, and so you can make some money to pay for your books or something, or, you know, going out for the summer. And I say, I'll pay you $200 just to go do it for every week for an entire month. And he says, okay. And he goes and does it. Now, that is okay if you pay your gardener also $200. But if you only pay your gardener $100 to come every week just to mow the lawn, and but you've decided that last minute, I told my son $100 and he goes, no way, I'm not doing that for $100. That's too cheap. And then I just make the decision, okay, I'll give you $200, just go do it. I don't want to hassle with this. You have a big problem, you better explain. So that could happen. I also had another one on one of the accountings I corrected that, and it was so sad to actually hear this, but so we have a conservatee, and you know, the conservator was the son. And when you have to take care of somebody 24 hours, 7 days a week, year after year after year after year, there's times you as a conservator just want a vacation. And you just want to, I don't know, go hang out with your boys because your best friends get married, and you want to go to Vegas, and we're going to go for a week and just go and go golfing and, you know, do things. But then you go, oh God, I got mom. What am I going to do with her? Right? In this case, we had, in this case where I saw, which was interesting to me, the son hired 2 sisters to alternate that week to come over and take care of mom. But the 2 sisters, who were older also, would not do it for free. They had to be paid, or they wouldn't do it. Mom wouldn't trust anybody else, and I really had nobody else to go to. So I went ahead and said, okay, I agree to pay you. I agree to pay you $20 an hour for how many hours. But that includes when we're all sleeping, you're still paying me those $20 an hour, because I kind of have to sleep, but I can't get a full sleep, because if she makes a noise and she wants to get up, or she gets up on her own to go to the bathroom, I have to hear her and I have to wake up and go do it with her. The problem wasn't that the sisters were hired to come over and take care of her. And that doesn't mean that you can never go on vacation without your mom. Yes, you can. But it had to be disclosed, and it had to be disclosed in a manner of the sister's name. I paid and state her full name to come over this week. They were there for 7 days, 8 hours a day. And I paid this amount of money, and it was like $20 an hour. And so I had to fully disclose it. Now, at this point, I don't know if the court's, gonna approve it, or if they did approve it, but they were like, oh my God, what happened? And I don't know, the other thing that may happen is it may be a chargeback back to the conservator, because the courts may say, well, that's your expense, that shouldn't be hers. I don't think so. But I told, I don't know if that will be something they get charged back for. But if you hire a family member, just remember, it cannot be for anything more that per hour, let's say, or anything more per job, then you would have hired somebody else who was a non-family member to do the work. But you can hire family members. So you'll be able to read that in this section right here. Okay, so the next is your compensation. So in this case, and I'll just use this example, this person must not live or care for the conservatee 24 hours, 7 days a week. She must be in like a facility. So maybe he went over, he checked on her, maybe he brought her clothes or incontinence, or he could have bought, you know, toothpaste, or maybe she wants wigs, or I don't know, whatever, you know. So this is what he did. Maybe he took her to dental appointments and, you know, stuff like that. You have to state how many hours you spent. And in this case, so if you read the example, spend 150 hours, that's my mom. I visited the care facility once a week, made sure she was receiving proper care. I've paid all of her bills. I've managed her estate frugally. I arranged for the sale of the automobile. I listed it, you know, and everything that happened. Now, up to this point, I'm in a state, I have received no compensation for my services. And so in this case, for 150 hours, they were requesting $500, which is a very nice fee. So a conservator, who is a non-professional fiduciary, is allowed to charge $75 an hour. That's according, or that is consistent with the local court rules, which I don't have on my paper here anymore. I believe it's local court rule 7.450. Or it was lastly, I don't know if Rex has it in the detailed information, but it's $75 an hour. And if that's your mom, your dad, somebody like that, you determine whether you believe, you feel you should be compensated for. I will tell you, a conservatorship is a whole heck of a lot of work. It's not just they're in a facility and let them handle it, and it's not that big of a deal. And oh my gosh, it's insane to me. It's a lot of work. In fact, it's kind of more work than your own children, because you got to count and talk about it. So or you have to count and explain yourself, and other people are looking at it, whereas taking care of your kids, like if they missed a bath one day because you had 100 loads of laundry, and another kid that you got it all folded and they went and threw it all up in the air, and you had to start over, so you couldn't give them a bath, and so then they fell asleep and you were doing dishes, and it was just too much to give them baths, so you did a quick sponge, whatever. Nobody's gonna care, right? Really, you're gonna promise nobody will really care, not even the kid, because they won't even know it. But with a conservatee, you cannot treat that way. It doesn't go like that. Yes, they need to be bathed. Yes, they need to be cared for. Yes, you know, if diaper changing and new clothes and washing clothes because they had accident in their other, I mean, you have to get it done. So, and you have to report kind of, you know, what you did. So I always say, keep kind of a log list of what you did. Be reasonable when you ask for compensation, but don't take it lightly. The other thing would be, I will tell you something like, say your conservatee really doesn't have anything. Your conservatee only gets retirement and like a small pension. So they get monthly $3,000, let's just say. And for their, like, they still got to pay a little bit of, let's say Medicare, Medi-Cal, they still have to pay food. They still have maybe a couple dollars prescriptions. They still have a few expenses that need to be paid. Maybe it's mortgage on the house. Maybe it's insurance to keep the house. It could be, you know, a few other things. So they really don't have any money for you to turn around as a conservator and say, I want $5,000 because I've spent all this time this year doing that. And you know, the conservatee doesn't have $5,000. Asking for it will be a little ridiculous because you know they don't have it. Like, well, the courts aren't going to come up with it and give it to you. So thinking about it, think about it reasonably and just be understanding. It's more your obligation. Mom took care of you till you were 18, sometimes longer. So you're spending a few years giving it back to her. So again, your compensation is not necessarily based on your hours at $75 an hour. It's really kind of considered like, can the conservatee afford that? They're not going to bankrupt the conservatee just to make sure you get paid. It's not going to happen. So that's one thing to consider. Usually if you're a pro per and you're completing this, you won't have attorney compensation. But if you're completing this for an attorney, you would state who the attorney, what they did, and how much they want as compensation. Again, this is one of the cases where if you don't have an attorney, you leave this out. You would not include it just because I have it on my sample. We're going to get down to veteran benefits. This is missed on all three of the accountings that were turned in. Also, the petition that went with it. You cannot skip this or not put it in. It is very important that you say whether the conservatee is receiving money from the Department of Veteran Affairs. Second one is also, you must include it. You need to state if the conservatee is a patient or was a patient in the state hospital. The conservatee's address, this is not something you must do. It's a very kind and nice way to put in your petition and tell everybody where the conservatee lives. I have known on a few accountings that I've done that I've done for clients that it was not in the best interest that all parties knew where the conservatee was. Maybe she had children she didn't get along with, or sisters, brothers, maybe family members who had in the past maybe came to try and harm them, or, you know, for whatever reason it is. If you have, or if you're concerned that stating where the conservatee lives would put them at harm because somebody knows now their address, then do not put that in, but it's not a requirement. So statement of accounts, this is where you're stating to the court that you've submitted original bank statements. I'm not sure if Rex in his talk showed you the cover letter on how to submit original bank statements. They are confidential before, where they really had a system. What I would do is what they call redact, which means I would black out with a black permanent marker the first three letters. I tend to sometimes black out information like what's the average daily balance that stays in the account, and some information that really has nothing to do with the accounting and I just don't want outside people to get a hold of. Original bank statement must, I don't know why my nose is so itchy. Original bank statements must be delivered to the court. If you don't have them, you must go to the bank and have the bank print the bank statements, and then the bank will put their stamp on that paper that comes out of the printer that said it's kind of they printed it and not you. And so that will be required. You cannot go and do online banking and then expect for the courts to just print the bank statements. That will not work. They must be originals. So, and again, if you don't have the originals delivered to you, I always suggest, although it costs some banks $3.50 a month to have the paper copies come to you, you're going to have to pay that expense because you need to keep them and turn them into the court. So again, if you don't have them, you need to go to the bank and have the bank stamp them and get copies from the bank. Okay, so now we're going to get down to capital changes. You would indicate if there's any capital changes, stock market crashed, COVID, whatever. You would indicate if there's huge losses. I wouldn't say if you're talking a couple of dollars or whatever. Okay, they know it happens. The statement of liabilities, in this case, I've already indicated that there's a mortgage. So I will indicate that here. I will indicate if there's any other liabilities the conservator owes, like a credit card statement. It could be if they had a loan, anything else like that, I would state that here. Sorry, I think I skipped. Nope, I'm on it. The next thing that must be on your petition is special notice. There's no special notice on this file. What does that mean? I'll give you a quick sample of what that means. What does the special notice mean? I myself, for no reason whatsoever, I don't even have to have a reason, I can file a form with the courts, $40, that every single thing that happens on this case, I get notified. So that means every petition you turn in, every time there's a hearing, every time there's an objection, anytime that anything happens on your court file, I get a copy of what's going on. So most of the time, these could be filed by people who may not be beneficiaries. So say you have a cousin who isn't a beneficiary because their mom is the actual beneficiary, but the cousin just wants to know everything. They could take $40 and file and see everything that's going on. So maybe they can explain it to mom, or if they think that something foul or crazy is going on with the account, they can file for a special notice. The other time I really see the special notices is those inheritance advance lenders. Man, those, apologize if you're one and you're on here, but I think they're sharks. Basically, what does that mean? They find out that beneficiaries are going to inherit, and they will go to those beneficiaries ahead of time. When I told you probate typically takes about 1.5 years to close from beginning to end, and before you get a distribution. And so what will happen is these inheritance advancers will go to the beneficiaries and say, I know you're going to get about $50,000, or no, let's say, I know you're going to get, $100,000 worth of inheritance once this is done and closed. Right now, if you would like to have some money, I'll give you $25,000, but in return, you give me $50,000 when you get your inheritance. Now, me, myself, I'd say you have lost your dang mind. That is insane and crazy. Why would you give me $25,000, but I have to give you 50? That's almost double. And really, it's almost double. I think it's like 40% that they charge. But 9 times out of 10, it is the wild and craziest thing I've ever seen. But 9 times out of 10, people do it. And I'm like, wait a minute, what? Like, just so you can have the money now. Oh, I'll take the $25,000 now, but have to give up 50? There's no way I'm going to do that for 1 year. No. I myself would never do that, but everybody's doing it. So in that case, if somebody does a inheritance advance, what will happen is you'll get an assignment that will be mailed to you as the conservator, and they will file their own special notice, which means every paper you file, they get a copy of. Okay, so you will state on there, if you don't know, like I said, you will know if somebody filed a special notice. That means just keep them informed. And so you put that on there whether or not. So now we're at the end, and so you're saying, okay, I completed the petition, I told you everything, now what do you want, like, basically. So your words would be, as conservator, I pray and ask the court to do what? I pray that this account is approved and settled. Sometimes they'll cross this out and put accepted. That my acts that I've shown in the account period are approved or accepted. That the sale of the automobile is approved. That the sale of the furniture is approved. That upon settlement, which means acceptance, approval of this accounting, I'm authorized to pay myself $500 as compensation. In this case, I am authorized to pay the attorney. Remember, you can never pay an attorney prior to your accounting and approval of the court. You can never pay yourself prior to this accounting and approval of the court. Again, you would not put these words in here if you don't have an attorney. And then you want the court to grant any other relief they feel is just and proper. You would date it and you would sign here as the conservator. Now, again, in this case, we have an example with an attorney. You would just leave this all off. And then lastly, there's one more thing, is what's called a verification. A verification is only used when you have an attorney that's on a case. So if you are submitting this yourself, you would not include a verification, but instead your last 9 would be, I declare under penalty of perjury. What this is, right? So that last line would be up here for propose. What the verification is this is just the conservator stating that, yes, the petition filed by the attorney was my words and was my knowledge and was my facts, and I declare under penalty and perjury this is true and correct. There are so many times, I'll tell you what's funny, that I've had attorneys and people call me and they're like, Tamara, I don't understand, the court, you know, it keeps continuing my case and they keep telling me they need a verified deck. And I'm like, oh, that's easy. Okay, I'll give it to you. And they're like, what are you talking about? We've been over and over. We don't even get what is a verified deck. What is a verified deck? And even LDAs who do the same work as me have called and said, I don't get it. What's a verified deck? This exact page is a verified deck, what they call a verified deck. So it is a verified declaration that states under penalty of perjury this is true and correct. That's all it really states. And what you're talking about, what are you verifying? So if you ever get notes that say you need a verified deck, this is actually what that means. So it is a verification stating that you have said this is true and the correct to the best of your ability under penalty of perjury for the laws of the state of California. So that would be the ending part of it. Oh, and here is, so here's a sample just on pleading paper that Rex used his own heading, but how you would record the original bank statements. I typically don't put the first account, I just will put original bank statements. And to me, I write confidential original bank statements, and typically I would write confidential here. And so this would be the cover page. And sometimes they say, why a cover page? Well, the court wants to be able to put their filed stamp on here or somewhere, and on a bank statement, there's no room for them to put that. If they stamp the bank statement, they probably lose some of the data on that bank statement. So they will like a cover page so they can mark this filed, scanned, whatever they do with it. And they know what you're submitting that's behind the bank statements. So that's the end of my petition. If no one else has any questions, I don't know if Rex wants to end it. We went about 12 minutes later, and sorry, but I wanted to give you all the information. But does anybody have any questions on the petition?
I just have another question, but it's more specific to our situation. Should I ask you it after?
No, sure, go. Well, anybody who wishes to leave, hun, can leave, or you can stay if you want. I don't, Rex, do you have anything more you want to say before I take her question? Did you ask him to fill out the?
Yeah, we do have an evaluation form that we request that you fill out and send to the Contra Costa County Law Library. But other than that, I appreciate all the participation. There was a lot of people on the class today, and we're here all the time and doing court accounting, tax, wills, trust, and estates. And we sincerely hope that this class was of benefit to you and that you will improve your court accounting in the future.
I have a question.
Yeah, I'm waiting for the questions. I wanted him to just say
Okay.
hi, say goodbye, and then I'm still.
The question may be beyond your scope of discussion. My question is, we had disbursements and income for the conservatee prior to the date of the letter. Is there a way to handle that?
Yeah, you don't include it. That's not your responsibility. You don't include anything that happened prior to you getting letters, so you just leave it off.
Just, we cannot include that
No,
in our filing, in accounting.
well, if you wish to include it because that you just feel better including it, you just have to make sure your inventory and appraisal balance starts where before that those items came in.
I see.
Does that make sense? So again, if you didn't get your letters till March 20th and you're doing your inventory and appraisal, but you want to include deposits and expenses that happen on March 15th, you just have to make sure your inventory and appraisal balances on March 15th before those transactions happen are included on the inventory and appraisal. But there's no need. I mean, you're setting yourself up and making yourself liable for income and expenses that you're not responsible for.
And I'm calling in regards to the primrose.
Sorry.
That's okay. Did that make sense, hon, or did that
Yeah.
answer your question?
Okay. Yeah, I see that basically what you're saying is I can include those income and expenses in the accounting for the first year. That's allowed.
Yes, sir. As long as you've adjusted your inventory and appraisal to handle the income and expenses you're going to be covering.
Okay, all right, I understand. Thank you.
You're welcome. I know somebody else had a question. I'm sorry. I didn't mean to skip you, hon. Go for it.
Well, first now that just brought up a different question, real quick one. So you're saying the date of the letter. We have temporary conservatorship right now, and we have a hearing on August 5th for permanent. Which date do I use? The temporary date or the permanent date?
You're just like another person on here, Maria, which I talked about earlier. She's also on a temporary conservatorship. Hun, it's the day you got your temporary conservatorship orders. You are responsible. The day the judge issued an order and told you you were responsible.
Okay, perfect. And then my more specific question is this. The conservatee owns a house in which we are the process of selling, but it is under a trust. So I know that we don't need to report on any of that because it is part of a trust. But my question is, in the process of selling, there's dry rot, there's things that need to be rodent stuff that need to be paid for before the sale of the house that are his responsibility. Can that come out of his conservator account?
Does he have a different account?
He had, well, he'll get proceeds from the house that will go into a joint account that he has with his sister that won't be part of the conservatorship.
Can't do that.
You can't do what?
You cannot like sell a house that's his property and then, okay, understand this. And so let me give you a sample. When you have a joint checking, savings, money market, a bank account, when you have a joint account between, let's say, A and B, and A and B are not married because that's totally different. That's a totally different ball there. So A and B are not married. So you have brother and sister like your sample. The only thing is a joint checking account kind of has what's called right of survivorship, which means that if either A or B passes away, it automatically goes to the other person, right?
Right. Yeah.
So that's really sad because if A has a house he's selling that you're selling just because he can't live in it anymore, and A ultimately wanted the house or wanted beneficiaries of his money to be his children. So C, D, and E. So A wanted his money to go to C, D, and E, which he states in a trust. And you put house sales in a bank account that automatically goes to his sisters. Guess what C, D, and E is going to get if he passes away? Nothing. Because
Well, so sister is his only living relative, so she's both. She's both the beneficiary.
But it doesn't matter. That's not for you to really kind of determine. That's more for courts. You have to open up an account that is only for that conservatee, and that's what you're responsible for. You can't even mix money in an account. So say he's getting Social Security or retirement pensions. If you put it in the account that the sister has access to,
no, we're not. We have a separate conservatorship account and all of his income is going into that account. There's another joint account that he was using prior to the conservatorship that his sister and him are a part of. So I'm just wondering where the money from the sale of the house will go.
Absolutely in the conservatorship one that you control.
Okay, even though it's in the trust, the house is in the trust?
Doesn't matter. Yes.
Okay, so it needs,
You're
all that
turning
money
it-
needs to go into the conservatorship account that he makes off of the house.
Correct.
Got it. Oh, that's huge advice. I had no idea. Okay.
So it goes in and you maintain control, because if you think about it, and let me just give this sample, you put it into the account that the sister also is, let's say, part of, let's say.
Right.
And again, you cannot control whether that sister goes out and I don't know,
Gotcha.
goes on vacation to Fiji and takes a plane flight and uses the money. And she says, you can't stop me. It's my bank account. Like it's my money too. You're responsible. And if it came to the court and anybody else said, wait, why is $10,000 missing because somebody went to Fiji or whatever, they could come after you as you were responsible for that asset. You were responsible for making sure it did not disappear. Now,
Got it.
that doesn't mean you can't pay expenses that you needed to pay. So when you were talking about, oh, maybe there was rodents or, you know, whatever you need to do to get the house in a sellable condition, that doesn't mean completely upgrade the entire kitchen and
No,
spend.
no, no. It's just
Right.
that one items that the
Right,
seller.
right.
Yeah.
You are responsible for kind of doing and paying from the conservatives account to upgrade that house and make it to where it's a decent sellable, you know, living space, and then put the monies into the conservatives account.
I got it. That makes a ton of sense. That's huge. Thank you for that. advice.
Otherwise, hon, you're putting yourself up for a huge liability. And you say that sister right now is the only living beneficiary. Wait till, and I hate to say that, wait till that man dies and wait till you see how many people appear in court and say, I'm brother, I'm sister, I'm adopted daughter, I'm, yeah, watch.
Okay, got it.
And then you're like, but I thought the sister, so I thought it was okay. And then it's too late because sister can't replace that money. And then you're putting yourself in a huge mess. Don't even go there, hon.
Okay, that clarifies a lot. Thank you so much.
Any more questions before we say goodbye? And I thank you again for continuing on the extra 20 minutes.
Thank you guys for doing this.
Yeah, you're welcome. So I don't know if Rex explained, but we do this about every 2 months. It's usually the third Thursday of those every 2 months. The Contra Costa County Library has a schedule. Usually when we get down towards the end of the year, where it's the holidays and stuff, it's going to be, it might change a little bit because the third Thursday is going to get close to Thanksgiving, Christmas, and all those holidays. And then when it will continue on to next year, the only problem that we have is him and Rex and I both do tax return stuff also. So from January to April, we're very limited. We might offer a class in January, but I don't think we do February, March, or April. So we'll skip that. But you are allowed to take this class as many times as you want. You are allowed, and it's free of charge. And, you know, nobody knows that you've taken it 100 times if that's what you need to do. But most of the time, the class is very similar, almost exactly the same. So you may say, oh, I'm not going to learn anything. I could give different examples. Typically I like to add in what I find from now until then that may have happened that I really want to share. So you're allowed to take it as much as you want. You're, you know, allowed to, you know, just come in and verify or anything like that. So don't be shy about taking a second, third, fourth, fifth time. Nobody knows. So, and we hope you like the class. We hope it's been helpful. And if there are no more questions, I will end it and let you all go have lunch.
Thank you so much.
Thank you.
Thank
for
you.
attending.
Thank
Okay.
you. Take care.
Thank you.
You too. Bye.
Bye-bye.